My lord, may I be permitted to mention one matter, my lord? My lord, this matter relates to the dismissal of petitioner from the service of LIC.
You want
My lord,
inclusion in the list?
my lord, it was supposed to be on the list on 25th for hearing, but it did not come in the list. Kindly fix up any date as per your lordship convenience before puja vacation. My
What?
lord. It's for hearing, my lord, for inclusion in the list.
Okay,
Not too time. My lord, may I be permitted mention one matter, my lord? Inclusion in the list, my lord,
Which matter?
by order dated 25th.
Which matter?
My lord, this is WPA 23321 of 2016, wherein my lord was pleased to direct register administration to instruct concerned police station to intimate bank officials to appear as to why necessary direction will not be issued against them. My lord, I have filed a can for partial modification of that order. My lord, I am praying only inclusion in the list of
Are
that
you the
can.
advocate on record?
Yes, my lord.
You don't appear on the date fixed.
My lord,
You
I-
genuinely don't appear. That is why this kind of orders
my
are
lord,
passed.
other advocate was there. However, I don't know what happened.
Anyway,
My lord,
next.
I am praying only inclusion in the list, my lord, of that can in my lord's list, my lord.
What is your name?
My lord, Moumita Ghosh.
Item number one, I am for the appellant. Here the case under section 163A, and lordship the parents are the claimants, and during pendency of the appeal, the mother of the deceased died. Lordship, I will file an application for expunging the name of the applicant number 2 is the mother of the deceased. So kindly lordship allow this application for expunging the name of the applicant number 2, and this is the 163A. The Lane Tribunal, I have prepared an appeal. On that score, the Lane Tribunal deducted
You filed the scan application in 2021.
lordship.
What about the legal heirs?
There are no other legal heirs that I have stated. Except that no other heirs of the applicant number 2. And the death certificate that I have annexed is number 5.
Sure. Appellant number 2 had been the mother.
Mother.
The learned advocate representing the appellant claimant submitted to a file a CAN application being 2 of 2021, which inter alia stated that the appellant number 2 had expired during the pendency of the instant appeal on March 19th, 2021. The said application had been supported by a copy of the death certificate of the same. The learned advocate representing the appellant claimant further submitted that the deceased appellant had not been survived by any legal heir or representative. The department is directed to amend the cause title of the Memorandum of Appeal deleting the name of the appellant number 2. And 2 of 2021 is accordingly disposed.
3A appeal, only the 5 lakhs is amount.
3 lakhs award.
Next, paper book filed by the learned advocate representing the appellant claimant we kept on record. Heard the submission of learned advocates representing respective parties. Next date fixed on 12th of November for audits. What is the other can now? Application.
No, 6 question.
What are going to discuss? Next. Correction.
I met in petitioner, my lord. My lord, the matter was ki come up for hearing, my lord, 4th August 2020. That order sheet
Fixed on 21st September, which is a Sunday.
the instead of August, my lord.
Can you fix any day, man?
Next week, my lord, any day, my lord. My lord, everything is complete, my lord. Very short matter.
August 28th.
My lord. Grateful.
Next.
I can see that I have to observe the appellant. In this case, I have already filed the notice of service of notice of appeal. With appearing not, it is not known to me, Mr. Scott. But I take it that somebody would appear on the next day. Can you add on it?
The learned advocate representing the appellant claimant is present. None appear to represent the respondent insurance company. Next date we fixed on 25th of August.
Your application, my lord. This is the disposed of matter, ma'am.
Lordship's mother-in-law of the deceased expired, and hence Lordship's rest of the respondent claimants already make party. Lordship's delete the name of the Amula Noskor. Nothing. Appropriate order. I have stated in paragraph 3 in application.
Person who has died happened to be the mother of the
Deceased.
the other legal heirs are already on record. The learned advocate representing the respondent claimant submitted to a file an application being CAN 2 of 2025, which inter alia stated that the appellant number 3,
Respondent number 3.
Respondent number 3
Lordship in appeal respondent number 2. Amula Noskor.
She has not written the number of the respondent in the
application লিখেছি কিন্তু লর্ডশিপ in appeal respondent number 2 লর্ডশিপ অমলা নস্কর.
No, in the CAN application she has made her a party to the number 3.
Application lordship I have stated it's wrongly. Pardon me, lordship.
Who is this Sheila Noskor?
Sheila Noskor, wife of the lordship Samapada Noskor, deceased wife.
Wife of
Tell me, madam, record টা না দিলে তো you have filed, you can't even assist. Number 2, respondent number 2, to have expired on 21st of February 2025. The said application had been supported by a copy of the death certificate. The learned advocate representing the respondent claimants further submitted that the legal heirs of the deceased respondent number 2 are already on record. The department is directed to delete the name of the respondent number 2 from the cause title of the memo of appeal. Can 2 of 2025 is accordingly disposed of. Now tell me what else. It's your appeal.
My lord, Amula Noshkar was respondent number 2 and
It's
Ishan.
over. You come to the next stage. Why did you file the appeal? Who will file the paper book?
My lord, this is the disposed of matter
disposed of, Lordship.
on 10/12/2024.
Disposed of matter.
They have received the money.
Lordship, already 2 claimants received. And Amula Noskar, Lordship check is pending. That will be Lordship's in
Where's
favor
the
of.
prayer?
If Lordship just received, if the before application file is not received, Lordship. Later. Application Lordship filed before that, Lordships. That's why I have
The respondent number 3 has, I mean, the deceased respondent has already received the compensation.
No, my lord, all
Respondent
the
num-
other respondent have received the
Received.
compensation and Amula Noshkar could not receive the compensation because she has died.
Madam, then what will happen to her portion of the,
her portion, Lordship,
Her
is the
portion
name
will
of
be the name of Sheila
where
Noshkar.
is that prayer?
Lordships. I have stated in paragraph, Lordships. 5
Next.
Lordships. Expunge the name, Lordships. Then under the prayer, Lordships, expunge the name of the Lordship. Already, Lordships, in paragraph 3, who was mother.
Please, madam, explain it to her. She needs to file an application. Next.
ফ্রেশ অ্যাপ্লিকেশন করতে হবে ভালো করে লিখে যে কে পাবে
আমি বুঝেছি।
প্রেয়ারটা দিতে হবে তো প্রেয়ার পোর্শনে নেই
Lordship, paragraph 4 I have stated, Lordships.
Supplementary নিয়ে নেন একটা
Lordship,
this first time appearing, there are 2 applications, one for condonation of delay and another for stay application. My lord, this is the copy of statutory amount.
You have given the copy of the
Yes,
talak?
yes, just now given.
148 days.
148 days delay.
Five to 9. 4 weeks. Serve notice, file affidavit of service, next date 18th of November.
Get put. 6 also, this my appeal, my lord. There are 2 applications, my lord. One for delay and one for stay. Mr. Rahman is appearing for the claimant. He has filed one independent appeal.
It's within time.
No, my lord, delay. Delay application is there. The আগে ওটা form টা নিয়ে তবে তো 55 days delay.
Five to 10. 4 weeks. Serve notice, file affidavit of service. Who will prepare the paper book?
Mr. Raman is appealing, my lord.
Oh,
Mr. Raman.
then he's already there, so you need not serve.
Yes, my lord.
So, 4 weeks.
4 weeks.
18th of November.
Let this appeal be tagged to this appeal.
The learned advocate representing the respondent claimant submitted to have filed a separate appeal arising out of the same incident. Being FMA 471 of 2025, the department is directed to tag the case record of the appeal being FMA 471 of 2021 along with the main appeal on the next date of hearing.
Yes.
Who will prepare the paper book?
I shall prepare.
The learned advocate representing the respondent claimants intends to file the paper book and the same is allowed. Now you need a TCR?
No, I do not. But I have all certified copies. But I have all certified copies.
Next.
Lordship, this is my appeal. Appeal is within time. I'm filing the statutory deposit, pressing for the stay petition today.
The report of the stamp reporter mentioned the appeal to have been filed within time and in proper form. Let the same be admitted. 4 weeks, serve notice, file affidavit of service, 19th of November.
Deeply obliged.
Look, this is insurance appeal appearing for the first time. There is a delay application in this case. I have made the statutory deposit as praying for interim stay.
How many days delay?
Delays of 351 days as per my 351 as per my calculation.
394.
394. 351. 394. But I was praying Lordship will kindly.
Three, 4, and 5.
Grateful to your Lordship.
4 weeks.
4 weeks.
Serve notice, file affidavit of service, next date 20 November.
20 November. Obliged to your Lordship.
Next.
Milord 9 is also the similar application. Milord, in this case also, Milord, there is a condonation of delay application. Milord, I was praying for interim stay.
How many days delay?
236 days, Milord, 236 as per my calculation.
244. Three and 4. Same date.
Lordship.
4 weeks, serve notice, file affidavit of service.
Lordship.
Next.
Milord, item 3, your Lordship, Milord, fixed asked me to inquire. Mr. Porimal Pahadi is appearing for insurance company. My Lord, I fixed
In
the
which
25th of
matter,
August.
Mr.
Item-
Mondal was there?
Yes. I have informed you, Milord, that this part.
You inform Mr. Pahari to be present on the next date.
20.
10, my lord, I'm appearing on behalf of the appellant insurance company. This is the, I've deposited 25,000. This is the copy of the challan, my lord. I'm praying for stay. There's no delay. Delay.
The report of the stamp reporter stated the appeal to have been filed within time and in proper form. Let the same be admitted. Delay আছে নাকি?
No.
4 weeks,
My lord.
serve notice, file affidavit of service, next date 21st of November.
My lord. My lord, not in this one. Not in, I'm sorry.
11.
11, I'm appearing same as item number 10, my lord. There is no delay. In this matter, my lord, one execution case is pending. The money will be disbursed tomorrow, my lord. It is an execution case of 61 of 2025. Only, my lord, will kindly stay that for till the time I deposit, my lord.
That order is there.
Number, if my lord kindly mentions that execution case number 61 of 2025 before the tribunal, my lord.
Which tribunal?
It's Alipur.
Where is the copy? of order?
My lord, will keep it at 2 p.m. I'll give the order. The next 3 matters, my lord.
Similar
11 to
matters.
similar matter arising out of the self-same accident. Grateful, my lord. Deeply obliged.
I am for the petitioner, my lord. Yesterday, they have surveyed copy of the opposition, my lord. My lord, I gone through the opposition. They have stated, my lord, I have not, my lord, supply my lord, caste certificate. That is a false allegation, my lord. I file a reply, short reply. Only 3 days is required, my lord. Yesterday, my lord, after 2 p.m., my lord, they supply a copy of the opposition. They have stated, I have not submit my the caste certificate along with my application, but they have issued the admit card as a SC candidate. But thereafter, they have considered my candidature as a general candidate. What is the, I have filed a reply,
What are you filing today, sir? Affidavit in opposition to the main writ petition.
Main petition as also supplementary. I have thought, my lord, it should be completed.
You are representing the state respondents. The learned advocate representing the state respondents has filed the affidavit in opposition to the writ petition as well as the supplementary
Yes.
affidavit filed by the petitioner. Let the same be kept on record. You need time.
Only 3 days time.
We'll file a reply to this.
Reply, madam. Yes, madam.
Learned advocate representing the petitioner seeks time to file an affidavit and reply to the same. Next date we fixed on 9th of September.
Deeply obliged.
Item number 9, I appear for the respondent. I want to file the paper.
Come on the next date. Next.
Paper 20.
My lord, in 20, I beg to appear.
I am filing my supplementary affidavit and affidavit in opposition.
My lord, supplementary affidavit on behalf of the respondent number 1 to 5, against which they have used their opposition. We want to file a reply, my lord, against this.
What is the issue that you are going on filing?
My lord,
affidavit of-
the issue is regarding a malpractice by the delinquent employee of selling out properties of the railway. Then during inquiry, my lord, putting it back a new one. So this is the charges, my lord, a grave charge against
Which property?
the property of galvanized sheet, my lord, which was under the custody of the inspector. And he sold it, my lord, a court of inquiry, and my lord, also opinion of the experts find out that there differs. So there was this. My lord, then, my lords, there was an order of stay that we will not come up with the award. Subsequently, my lord, Justice Dattopal, my lord, directed to publish it, and as per the order, my lord, we have filed that supplementary. We have filed that supplementary affidavit. And
Today?
Today
you have filed it.
Yes, ma'am. My lord, opposition, we have given it to them. They have filed the opposition. We want to file a reply. Annexing both the inquiry officer's report and, my lord, the
This
disciplinary
supplementary
authority's award.
affidavit that
Milord?
your supplementary affidavit which you had filed on 6th of February 2025.
Yes, my lord.
So that
Supplementary affidavit that was filed on behalf of the petitioner. And we have filed the supplementary affidavit, my lord, on...
Sir,
my lord,
please listen to me first.
my lord.
This is of 6th of February 2025.
My lord.
Right?
My lord.
So you have filed this in compliance with the order of the coordinate bench. Supplementary affidavit on behalf of the respondent number 1 to 5.
Yes.
Sri Manoj Kumar Singh.
Yes, my lord. 17th of July.
So in compliance to that order, you have filed the supplementary affidavit, right?
My lord, that is there, my lord. My lord's order is there. We have referred it in paragraph 2.
Okay. The coordinate bench's order was on 10th of September 2024. Sanchal.
বলছেন
ওই কোঅর্ডিনেট বেঞ্চের অর্ডারটা যার ফলাফলে আমরা ফাইল করেছি এটা
এটা তো জাস্টিস Milord, if your lordship kindly takes up Milord's order on 24th of June 2025. Milord's order. এটা তো তারপরে
But then
25
this affidavit was asked to be filed by the order dated 10th of September 2024 by the coordinate bench. So you're complying that on this date.
Yes, Milord. And Milord,
The supplementary
has
affidavit
protected.
filed on behalf of the respondent numbers 1 to 5 in compliance with the order dated 10th of September 2024 passed by the coordinate bench of this court be kept under guard.
27.
The affidavit in opposition
Yeah, Sampadatto order.
filed by the learned advocate representing the petitioner to the aforesaid supplementary affidavit be kept on
I have
record.
also filed a supplementary evidence.
Wait. The learned advocate representing the petitioner has further filed a supplementary affidavit. It had been affirmed on which date, sir? Affirmed on 13th of August 2025. That the same be kept on record. Now you want to file an affidavit
Reply,
in
Milord.
reply to this?
To this. Let something be on record, Milord.
The learned advocate representing the respondent railways.
RPF.
Railways.
Railways. Yeah, that is.
RPF korra. How long will you take?
Milord, 3 weeks.
3 weeks time to file affidavit in reply to the supplementary affidavit filed on behalf of the petitioner today. Next date be fixed on 19th of September for filing the aforesaid affidavit in a reply. Yes.
Let my supplementary affidavit and opposition be kept on record.
Great.
Milord.
Don't exceed the date. I know you pretty well. Next.
My lord, I am praying for some time, my lord, because of fever, my lord, I could not get myself ready.
Mr. Ghosh.
My lord, I may be excused, my lord. My lord, 2 days I was at Delhi, my lord, at Supreme Court.
No,
Well,
first of all, listen to what I'm saying.
Well, I understand, my lord.
What do you understand?
2 days I could not appear, my lord. In 2 matters, my
Okay,
lord.
yes.
That, my lord, I missed the list because I thought one of the matter has been made CAB, so that's why I have not, my lord. Matter was made CAB, my lord, earlier. That matter, my lord.
Because you were not there. Thereafter, I
Yeah.
thought because you did not appear on multiple occasions. And subsequently, I
Well,
thought
I will
you-
next
you
day,
were-
my lord. My lord. On my lord, September 12th, September, possibly, your lordship speak, my lord. I have noted, my lord.
Yes.
I am, my lord, praying some time, my lord.
Sir, you will not be able to resume contact with your client.
No, my lord, that is in contact, my lord. Because of my fever, I could not get ready, my lord. Pleadings are complete.
What is the issue?
Issue, my lord, penalty, proceedings and penalty, as my lord.
Well, only one thing, my lord. Page 34 onwards, entire documents are in Hindi, my lord. So, it is very, my lord, difficult for me to read, my lord.
Page?
34 onwards, my lord, inquiry and my lord, other documents, all has been, my lord, annexed in.
But it is typed.
No, in Hindi, my lord, kindly see, my lord, 34 onwards, all are Hindi, my lord.
Won't be a problem for me. If it is a problem for you, I don't know. I can't read handwritten documents, manuscripts I can't read.
No,
But
all, my lord,
out in Hindi I can read.
my lord, I cannot, my lord. All documents are Hindi, my lord. Page 34 onwards, I don't know what is in the file, whether it is translated or not, but a copy which has been served to us, my lord, all are in Hindi, my lord. Page 34 and onwards, my lord.
Yes, from 33 onward.
33 onwards, my lord.
Yes, I can read. I'll read out.
I know, my lord, your lordship knows, my lord, Hindi, my lord, but
Anyway, but if it was in I mean, if it had been a handwritten copy, then it would be difficult.
my
But
lord.
then typed out, I can read.
Very well, my lord.
Anyway,
Then,
but do you have translated copies, sir?
for Hindi, sir. All Hindi, maybe.
But you asked them to provide. These
But-
are your documents.
Yes, my lord. They have, my lord, prepared in this, my lord.
These are your documents.
Yes, my lord. They have prepared in Hindi.
Ah.
So, in my lord, in our, my lord, filing
So far
system,
I
my
remember,
lord,
my
they, my lord,
Honorable
always.
Justice Somadar has been pleased to direct them to
Hmm.
make translation, my lord.
Which order?
My lord, today I not having the, next day I should test. Next day, please, my lord.
It's your order. Yes, in case any document annexed to the writ petition is in language other than English and the concerned respondent authority has difficulty in understanding, comprehending the same, it will be open to the said authority to ask you.
No, my lord, that is their document.
You read the order, sir. 10th of September 2015.
No, today I'm not having my lord, sir.
You don't have the
Today,
copy,
copy I don't have.
but it's the order says it will be open to the said authority to ask the petitioner to supply an English translation thereof, which has to be an official translation obtained from this court.
Yes, my lord. That's, I am asking, my lord, that copy, my lord.
So this order was already there. Acha.
My lord, their documents, my lord, let them do, my lord.
Hmm?
Petitioner is out of employment, their document, my lord, let them do.
Sir, there is an order of the coordinate bench. What are you saying? এটা দেখিয়ে দাও।
আজকে তো ফাইল খারাপ। Yeah, my lord, if the concerned authority has having a difficulty,
They can't read out.
no, authorities can understand, my lord. Authorities will supply. Authorities will supply, my lord. That's it.
কি বলছে? আমাকে দিতে বলেছে।
Yeah, authority, if you have any difficult authority,
The
if your officers
department
have any difficulty.
is to comply with the order dated 10th of September 2015,
Yes,
right?
my lord.
Passed by the coordinate bench of this court in translating the annexures to the writ petition into English language. A copy of this order be communicated to the concerned department for compliance. Then they will take some time. It's
Yes, my lord.
huge. Pleadings are completed.
Yes, my lord. Pleadings are completed.
Pleadings are completed.
Our originals were not traceable. That time, my lord, we have also handed over to your lordship, my lord, the photocopies of the, my lord, affidavits, my lord.
The articles are articles of charges. Few paragraphs have been transcribed in English, but
Major portions are, my lord, in Hindi, my lord. Since he is challenging the entire disciplinary action initiated by us, my lord, so, my lord, I think, my lord, these documents are required, my lord, for proper consideration of the
next
matter.
date be fixed on 14th of November.
My lord.
In the meantime, let them translate because
But so far I remember, Mr. Partha Sarthi বিশ্বাস was appearing. He translated some order and some placed. I know that is in the file now.
No, I don't know, my lord.
Parthasarathi Bishwas.
Advocate, non-advocate, senior advocate. He was appearing.
Previously, was appearing on behalf of the Union of India, my lord.
Sure.
But
He
I,
translated.
Okay,
my lord,
sir. Then ওটা ভালো করে চেক করে ট্রান্সলেশন আছে কিনা
But let him, my lord, serve a my lord, copy of that document, my lord.
Come at 2 p.m. Let them find out from the record
My lord,
whether the
My lord.
translated copies are there
My
on
lord.
record.
my lord.
2 p.m. My lord, junior remain, my lord. I have another court, Chief Justice Court. My if lordship sits, then my junior.
Let's go.
My lord, I am appealing for the petition.
Mr. Mitra is appearing on behalf of the Union of India, my lord. My lord,
My lord, administrative notice has
was issued, my lord.
My client is.
Yes, what is the matter, madam?
My lord, there was a direction, my lord, on 12th of March to file reply, my lord, to the opposition filed by us, my lord. 12th of March.
That after that, I am unable to contact my client, your lordship. After that, the administrative notice, now I am ready to file reply. If your lordship kindly grant me
So
some
now
time.
it is like each and every matter, the court will be forced to grab the petitioners just because of inaction on your part.
Unable to, my lord, affirm the reply, my lord, without my lord signature of the client. My lord, 10 days time, my lord, kindly grant me to file reply and kindly fix the date for hearing.
You had sought for time on 10th of June.
My lord, after that, my lord, I am unable to contact my client. For that reason, I am stayed before your lordship to serve administrative notice. For that reason, your lordship directed to present before your lordship.
চঞ্চল এর নামটা দেবে না তো, ও কোনোদিনই আসে না। On the prayer of learned advocate representing the petitioner to file the affidavit and reply, next date be fixed on 26th of August as last chance.
The matter will appear on
26th of August
My-
as last chance.
My lord, 26th, my lord, Mr. Mitra will be out of.
Next.
great, my lord.
Okay.
Office তারিখে fix করেছেন,
My lord. On the 26th, I will be out of station.
In any other case, the other cases also, you are not regular, sir.
I was regular appearing before your lordship, my lord.
When did you
Only-
appear? Did you appear in the last week
Yes.
in any of the matters? In which matter?
My lord,
In-
correction, your lordship has been pleased to issue administrative notice.
Date-টা দেখি।
30th July.
I always appear, my lord. If I am not, my lord, doing argument in other court of this Honorable High Court.
30th July, বলুন।
30th July.
30th July, I'm asking you about the last week.
Last week also, I appeared, my lord. I regularly appear in this matter. Administrative notice has been only, my
Then
lord.
why do your juniors
Yesterday
always
only-
seek time
Yesterday
on
I
your
couldn't
behalf
appear, my lord.
that
before
you are
your-
not there?
Yesterday only.
Not yesterday, day before yesterday, prior to that date.
I will be out of station before the Honorable Chief Justice Meghalaya, my lord. And Magnanimous appeal is continuing. That is the reason. If your lordship kindly fix any other day, my lord, for any day in the first week of September.
Go and call the advocate representing the petitioner.
I have to.
Next.
Number, my lord, I do. Very well. Don't go.
The Union of India is present, but the matter proper answering respondent will.
Respondent number 226
Yes, my lord.
ECA.
for internet.
So your respondent number one,
One.
none appeared to represent the petitioner. The learned advocate representing the respondent numbers 2 to 6 ECL appeared online. The learned advocate representing the respondent number 1 is present. The order dated 11th of July 2025 directing the learned advocate representing the petitioner to file the affidavit in reply had not been complied with. Let the matter be adjourned for the day as last chance. On earlier occasions,
Lordship, they will not okay, Lordship, field the hearing, Lordship. He will not appear.
he will not appear, then it will be dismissed, sir. Next.
No, Lordship, hearing may be fixed, I will argue the matter. I am interested in the argument, not for the
So you do it unilaterally. Next.
Whereas 48 is concerned, Lordship, we are for the respondent's Lordship. Lordship, may I have your Lordship's leave to file the affidavit in opposition?
Affidavit of service, I am for the petitioner. Oh, sorry. Copy of
Copy of the Lordship said after opposition Lordship was served upon their earlier lawyer. Lordship, there has been a lawyer change, Lordship.
been a change.
Because we had served their,
be given a copy of the affidavit of opposition.
we had served their earlier lawyer.
And I don't think
You have filed a fresh wakalatnama.
I had filed a fresh wakalatnama.
Lordship, there was probably a direction for filing the affidavit of reply also. Lordship, order dated.
It was filed on 5th February 2024.
No, did you file the affidavit in opposition?
Yes, Lordship, we have filed it now, Lordship. We have filed it now, Lordship.
Copy may be
So you
given.
give them a copy
Lordship, we don't have copy right now, Lordship, extra, because it was given.
to him during the course of the day or tomorrow.
And I may be given a chance to.
But for this, my Lordship, only one submission, Lordship. This case, Lordship, is of the year 2018, and Lordship, in the year 2018, this person was 59 years old. So, Lordship, now in
He has retired.
2020,
He
he
has
is retired. So, Lordship, this is not a case of this person has been dismissed. Lordship, there has been reduction of pay by 3 stages, Lordship. So, hearing is required.
3 stages of my.
It has a bearing on his
Discipline.
retirement benefit.
Yes.
His disciplinary proceedings was there, Lordship.
It has a bearing on my all retirement benefits, present pension as well as my gratuity. Everything got affected.
Hearing is needed, Lordship.
There was disciplinary proceedings.
Disciplinary proceedings, yes.
Disciplinary proceedings, I'll say, my lord, what has happened. I was posted in Durgapur in the respondent's company. And there, one MSCT case came up. It went against the company. The learned advocate, conducting advocate's opinion was that I should be, that case, the MSCT, whatever award has been granted, that should be satisfied. Complying with the advice of the learned advocate, conducting advocate there, which is on record, after the DCC meeting, jointly taken with the approval of the headquarters, the award was satisfied. The award amounted to around 28 lakhs. After the award was satisfied, it came to the knowledge of the writ petitioner himself that his limit to sign the check was 12 lakhs. He himself informed that I made a mistake, checks issued, checks encashed, kindly regularize my this thing. It is beyond the FAO, financial sanction limit.
So he was aware of it.
He subsequently came to aware of it when he was going through the procedures. And he was only posted in that position for only 2 months prior to that. There is no training imparted. Vigilance conducted and found him guilty. There is no misconduct as regards the settlement of the award is concerned. The only element is whether he could have signed a check of 28 lakh jointly with the other signatory.
What was the status of the other signatories? Were they eligible to sign?
He was, possibly branch manager was eligible to sign. He was the accounts officer.
And the petitioner was his subordinate?
Yes. With the approval of the head office, as regards the element of payment is concerned. Obviously, I am not saying that he had the authority to sanction was given by the headquarters to sign the check of 28 lakhs. The payment of 8 lakhs was approved. So that is the crux of the matter. Evidences I will be placing, how it has come. Let me meet the, give me a copy, let my learned
Whereas
friend
Lordship,
give me-
one is whereas one thing, Lordship, if my learned senior friend has an affidavit in reply,
opposition filed by
affidavit in
learned
reply copy may be given, Lordship.
Not confirmed.
Oh,
I'm not getting
আপনি
any-
ফাইল করছেন না শুনিনি স্যার সরি লর্ড সরি লর্ড
You're becoming too exuberant today, it seems.
no lord kindly pardons me I did not hear sorry sir.
The affidavit in opposition filed by the learned advocate representing respondent number 1, 2, and 3 be kept on record. A copy of the same is to be served upon the learned advocate representing the petitioner,
আমার নাম্বারটা নিয়ে নাও।
who intends to file the affidavit and reply to the same. How long will you take?
2 weeks.
Sir, 2 weeks will be 2 weeks.
I will add her to it.
Good.
I will add her.
Next date we fixed on 9th of September for filing affidavit and reply.
Lordship.
In every matter, you people are literally both.
Like mine.
I put the system in the Mr. Singh, madam. Already 5 easy notes of argument, madam.
Lordship.
Tell me what it just tell me for recapitulation.
Lordship, the petitioner joined the Calcutta State Transport Corporation on 28th of August 1985. So, Your Lordship, it is the admitted fact that they have admitted in paragraph 16 of their opposition that I joined the service of the Calcutta State Transport Corporation in 1985. And I am going to retire in 2019, but I took VRS. On 31st of July 2017, I got a VRS from Calcutta State Transport Corporation. So as per the scheme, Your Lordship, there are certain conditions which they have to fulfill while granting me the benefits under the VRS. That has not been given. Now, Your Lordship, after my retirement, without giving me the benefits of the VRS scheme, Your Lordship, they have disbursed an amount of rupees 6,11,206 as my terminal benefits. So I preferred a writ petition before this honorable court challenging that I have not been paid my terminal benefits, and that this honorable court directed the managing director of the respondent corporation to consider my representation and pass an reasoned order. They passed a reasoned order that I'm entitled to get the benefit of the gratuity and leave encashment for only 6 years. So, Your Lordship. So that order was under challenge before Your Lordship. So I have given my affidavit in reply. They have filed.
So they have admitted 6 years of gratuity and leave encashment. And what about you? What do you think?
My contention before Your Lordship that I have rendered a service for 32 years. So as per the Payment of Gratuity Act, I am entitled to get the benefits of gratuity under the Payment of Gratuity Act for 32 years, not the 6 years.
No, but then now I remember Mr. Sen said there was a change.
Lordship.
From one scheme to another.
No, that was not the scheme. The scheme was VRS scheme. That was admitted. The thing is that they have taken the plea that after continuing for 6 years, Your Lordship, I was not allowed to join my duty. I preferred a writ petition, Your Lordship, and the writ petition was disposed of by directing them to resume my duties. I resumed these duties, but they said that there is a discontinuation of duty. But my condition before Your Lordship, I have never been show-caused, never been charge-sheeted. No formal order was against me. And after the direction of the Honorable Court, if I resume my duty, so they cannot say that there is a breakup of my duty.
Breaking service.
Breaking service, that cannot be, because no formal order was issued against me.
Where is Mr. Sen?
He is always code number 30.
So I filed my written notes of argument.
I have also filed the written notes of argument on behalf.
Tell me what have you filed?
Hello?
Tell me what is there in your written notes.
Kindly say page 2 of my meeting statement. Page 2 of my meeting statement. Page
Arguments.
reading notes of argument.
Two.
When did you file it?
I filed on 14th May 2020.
Yes. Which paragraph?
Paragraph 1, page 2, subclause D. Right. The petitioner was not entitled to pension under CS Death Cum Retire Benefit Regulation 1990. The petitioner neither opted for pension under the order DCRB Regulation 1990 nor under the EPSC 1995 under EPF Act and miscellaneous position. Thereafter, if the principal claim of the petitioner is that the gratuity content should be calculated under the Payment of Gratuity Act 1972, treating the service tenure of the petitioner as 32 years instead of 80 years. Since he joined the service of CSTC as a student guard on 28/8/1985, letter by memo number such and such, 24 January
Okay, sir.
1990.
I've seen it. Ashwin. For the submission of learned advocates representing the respective parties. No, there is this. Next date be fixed on 22nd of September for orders.
Gratefully.
Claim কি আছে? না ওগুলো তো পরে হবে। For orders, no.
Number 127.
127, my lord, Mr. Shubhankar Mondal and Mr. Ashik Mondal is appearing in this matter. Mr. Ashik Mondal is unwell. He's suffering from grade 1 spondylitis. He informed me that he's having trouble sitting also. And Mr. Shubhankar Mondal is unwell.
You are for the.
I'm for the appellant.
The learned advocate representing the appellant insurance company is present. None appear to represent the respondent claimants. Next date be fixed on 24th of November.
My lord, grateful, my lord. Grateful.
I can understand about Mr. Shubhankar Mondal, but what about the other?
Mr. Ashik Mondal, he
has so many matters.
yes, he informed me that he's suffering from grade 1 spondylitis, which has been recently detected. So he's in a lot of pain. He's consulting doctors and all, and
Next.
হ্যাঁ না আমি জানি না।
Who are these?
The
One Mr. Shondip Bandopadhyay.
the Banerjee brothers.
No, that day he said that he appears on every day. So this is, I mean, 24 hours probably must. I kept today's list in such.
Phone call now.
Mr. Mondal, you have your matter next. Ask Mr. Roy to contact him. Mr. Roy, just find out where this.
Ruxmini Banerjee brothers के phone call.
ওই যে রুক্মিণীকে ফোন করতে বলছে।
And for the respondents, one Mr. MP Chakraborty and Ms. Ratna Deepa Kormukar. No, one or two, maybe I start dismissing, then only they will learn a lesson.
Should be.
Well, this is my appeal, my lord. The driver 46 years
Paper book.
expired. Paper book has been filed earlier occasion.
Let
Yes.
them. Sorry.
My lord, in this case, accident took place in the year 2021, 26 February 2021. My claim was, my lord, 12,000 per month, but under tribunal below taken 5,000. Tribunal below taken 5,000.
Tell me once again.
My lord, accident took place 26 February 2021.
Okay.
And my lord, according to Exhibit 6, that is the Aadhaar card of the victim, and my lord, age of the victim was 46 years.
Age
And
46.
46 years. There is no dispute regarding my lord multiplier. Claimants are wife and minor children, 2 minor children. My lord, since my lord 2021 accident took place and claim was 12,000 per month, my lord, income. Only 5,000 has been taken. And my lord, no future prospect has been granted.
What the deceased used to do?
My lord, by oral evidence, my lord stated he was a driver. No document, my lord, regarding driving license of the victim has not been exhibited, not been produced.
Then?
Yes. Only 5,000, my lord, 2021, my lord, kindly consider that also. My lord, here, my lord, page 25. Your lordships will find, my lord, middle portion. The
Future prospect was not granted.
Not granted. My lord, 25% will be added.
Future prospect not granted.
Only 2 issues I have come before your lordships. Income and future prospect. Other part will be.
What is the Exhibit 6?
Exhibit 6 is the Aadhaar card of the victim. Aadhaar card of the victim.
What does it show?
Well, no issue.
What did you mention?
Yes. And my lord, kindly see 5,000 has been taken, my lord. 2021 accident took place. 2021 expired. Kindly consider that also, my lord. If your lordship taken, my lord, minimum wages also, my lord, that will be much higher. 5,000 will not be, my lord. 5,000, my lord, I am leaving it before your lordship. My lord, kindly take this.
The driving license is also not there.
No, driving, my lord, oral evidence has been given, my
That
lord.
is why
He was
on the
maintaining
safe side.
during his lifetime. He was maintaining.
Learn something from him.
Yes,
He
ma'am.
creates Mason.
Yes. In case of a mason, my lord,
safe side that we have to prove.
maintaining his family, my lord. Wife, my lord, children are there. And my lord, kindly see page 11, my lord, 12,000 has been, my lord, by oral evidence, my lord, stated. The wife of the victim stated.
This page.
Page 11.
12, 5. I don't know.
And my lord, page 11, paragraph 5. And my lord, in cross.
Driver without a driving license.
My lord, and my lord, this person, my lord, may not be, my lord.
Driving what? Rickshaw.
Rickshaw. One, my lord, 2021. And my lord, kindly see page 13, cross examination. My lord.
Mr. Singh,
Lord, it is fluctuating, my lord, from 5,500 to
8,
700, from 5,500 to 7,500, my lord. Your lordship has
It's 7,521. 21, my lord, 7,500. Minimum, my lord, 20.
5,000.
Grateful, madam. Grateful appreciate.
কি করবো নাই মা হ্যাঁ করে
না না পরের দিন করো।
যা হবে
এটা 131 হলো রে।
একই তো আছে স্যার লোন তো একই আছে ফাদার আগে তো তো বলে দিয়েছে আমরা তো কোনো ইয়ে নেই
135 তো
হুম 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 ফাদার
but this is the insurance appeal minute for the appellant note this appeal minute was mainly found filed minute on the ground that the rash and negligent driving of the driver of the offender. It was a death case. An award of 53 lakh odd was passed. It has been secured before your lordship, not along with the interest. So I have deposited, 53 lakh 20,000.
53 lakhs,
53 lakh,
20,000.
53 lakh. The principal award was 53, 44, 800.
Now, why have you filed the appeal?
The police in its charge sheet, my lord, did not find the driver of the offending vehicle as rash and negligent. My lord, section 279 of IPC. My lord, specifically, my lord, it refers to the rash and negligent driving. In all accident cases, my lord, we find that 279 has been, my lord, put in, my lord, or the slap, my lord, against the driver of the offending vehicle. In this case, my lord, this particular section was not slapped. My lord, the section in the charge sheet, my lord, was 186. That is obstruction to the public servant in discharge of public function. 353, my lord, I'm referring to IPC, my lord. This is assault and criminal force to deter police servant from discharging his duties. And my lord, last one was 304. That is, my lord, punishment for culpable homicide, my lord, not amounting to murder. 279, my lord, was either omitted, my lord, or was deliberately not pressed against this driver. My lord, this is one of the main reasons, my lord, since the rash and negligent driving by the police was not, my lord, enforced against the driver of the offending vehicle. My lord, it's a case under section 166. My lord, I have come up before your lordship. My lord, there is another point as far as, my lord, the quantum part is concerned. My lord, there were 4 claimants. The father being one of the claimants, my lord, the father did not come to depose. So, my lord, I was praying, my lord, instead of 1/4 deduction, the deduction should be 1/3. My lord, these are the 2 specific points. My lord, now, as far as, my lord, the charge sheet is concerned, my lord, I invite your lordship, my lord, to page number 26 of the paper book, my lord. But though it's not a very sound case, my lord, as far as the charge sheet is concerned, still, because eyewitness is already against me. My lord, lordship, kindly come to page 26, my lord. 26. The charge sheet, my lord, starts from page 26. My lord, I would invite my lord, this is a running page 32 and 33 of this charge sheet, my lord. This is my lord, my lord, 32. My lord, the last but one.
Investigation, it
During,
was
I'm getting
learned
your lordship, my lord.
that on
During
24 to 20,
lordship,
such and such was performing.
My lord, here this line is against me. Due to rash and negligent driving by the
accused
driver lost control and dashed him
over.
the ship. My lord, this is against me. But my lord, as far as the pressing of the charges were concerned, this is the very next page, my lord, page 33. 4th line, my lord, 3rd line, charge sheet numbers so and so, dated so and so, under section 186, 353, 304. My lord, 279 is missing from here. So 279, my lord, deals with rash and negligent driving, which is not slapped in this case against the driver. And not in 166 proceeding, your lordship knows, my lord, that rash and negligent driving, my lord, is a sine qua non for, my lord, claiming compensation.
Where is
My
the
lord,
eyewitness?
My lord, eyewitness is, my lord, at page number 9, my lord, of my lord's paper book.
PW2, page 9. While my lord, victim was on duty, accident has been taken place.
Page 9.
Lordship.
Page 9.
My lord, eyewitness, PW2.
So what has he stated in the affidavit in chief? So this.
This is in, my lord, the chief was incomplete. This is incomplete part, my lord, that is why, my lord.
My lord, LCR has come.
TCR আছে?
My lord, the victim was a police constable.
Victim was police constable. While he was on duty, my lord, accident has been happened.
PW2 is the
Eyewitness. my lord.
eyewitness.
PW3 is the regarding
Salary.
salary, my lord. PW3 is the employer.
Not PW2 is the eyewitness.
PW3 is eyewitness.
So his income is not disputed.
My lord, income part is not disputed. My lord, as only my lord on the personal deduction. Because as far as the personal deduction was concerned, I would.
In the claim application,
My lord,
nothing was mentioned.
my lord, one line is there. My lord, I'll show it to your lordship. My lord, kindly come, my lord, to page number 2 of this paper book. At the bottom, my lord, just above the verification, the last paragraph, the deceased was an only. My lord, this is the only statement. Even, my lord, it has not been supplemented, my lord, in the affidavit part or, my lord, or in the, my lord, evidence part.
My lord, on behalf of my lord, here I am coming, my lord, before your lordship. My lord, here
The father does.
No, PW1.
There is no
PW1, my lord, is at page number 7.
Kindly see, my lord. On behalf of father, my lord, there is a cross-examination. Page 8, kindly see page 8, bottom portion. Page 8, bottom portion. That is the cross-examination has been done by the father of the victim. My lord, it is a fact that my mother-in-law had already expired. It is a fact that today I am depositing for myself and for my minor children, also for my father-in-law, Mir Kabil. And the statement which has been stated in the claim petition, there is no specific denial at all, not a single word. When there is no specific denial, well, it amounts to admission. Your lordship knows that. According to order 8 rules 3 to 5. That has been my lord cross-examined. And another, my lord, your lordship will find, my lord,
You have
kindly see.
filed the examination in chief.
Yes, my lord, that has been filed.
Where is that?
Not there.
And my lord, in
Not
paper
there in
book,
the paper.
It is not there.
my lord, in the my lord LCR, TCR, my lord, it is there. And
No.
Only these 2 points.
yes,
What
my lord,
else?
please see another, my lord, page 51, my lord, page 51 of this my lord paper book, where my lord Mir Kabil, the father of the victim, my lord stated, my lord, kindly see. The father of the victim, my lord. Kindly see, there was, yes, 51 of the paper book. There was another case. Page 51.
There was another case means?
Another, my lord, claim case was there. My lord, that has
Lord,
been
may I clarify? My lord, the claimants had filed another claim case, my lord. The claimants had filed another claim case arising out of the self-same accident. My lord, a declaration was made by the father of the victim that we have got that other case dismissed, so this case should be proceeded with. This is what declaration. Even in that declaration, my lord, he was dependent on his son's income. Even that is, even here it is not mentioned. Page 51. He had an opportunity at least.
When, my lord, the claim petition has been stated, dependent, and here, my lord, the mother-in-law, the mother of the victim expired, and my lord, the father was fully dependent upon the, my lord, the son.
Finished?
What?
Finished?
That is there, my lord. And learned tribal, my lord, observe that, my lord, there are a number of dependents are close. My lord, here in
that is why I'm
yes,
here before.
there is no specific denial, my lord. Here, my lord, Page 15, my lord, duty process.
An application under section 166 of the MB Act had been filed So this one would 136 will
No,
not be
no.
possible. Ashun. You are there in 136?
Yes.
The learned advocate representing the appellant claimant is not present. The learned advocate representing the respondent insurance company is present. Let the matter be fixed on 25th of November.
Fine.
By that time, probably they will be fit and fine. I mean, 137, who is there?
এই এবার অমিতদা শুরু করবে। I have preferred this appeal, my lord, on the point of non-involvement and contributory negligence.
Wait, let me just tell you.
My lord.
You said no default interest should have been given.
My lord.
Contributory negligence on the part of the son who
My
didn't
lord.
have a driving license.
My lord.
And according to he died out of COVID and not out of the accident. And the first complaint was filed after 41 to 42 days. And did he file any cross objection? And according to him, he was standing with his mother.
Yes.
Right? Okay. Now anything else?
I leave it to my lord. Only on the point of contributory negligence, I'll just point out one page. I'll just point out that page, my lord. It would be easier. Their FIR is at the relevant page is at page 25. That complaint under section 156(3), the relevant page, page 25. The first paragraph, my lord. ঘটনার তারিখ ও সময়ে অধীন তাহার মাতা লতারানী বেরাকে অধীনের নমিত এত নম্বর মোটরসাইকেলে চাপিয়া অফিস যাইবার জন্য তমলুক থানাধীন চার্টার্ড শুড বি বাস স্ট্যান্ডের নিকট ভারত সেফ শোরুমের সামনে রাস্তার বাম পাশে দাঁড়িয়েছিলাম ওয়ান্স দে সে দ্যাট উই ওয়ার স্ট্যান্ডিং, again they say that motorcycle চাপিয়া অফিস যাইবার জন্য. So contradictory statements, and admittedly
Yes.
if yes, and he did not have a driving license, that is there at page 14. I do not have any driving license till date. So that contributory negligence portion, at least some percentage in it's my argument that it should be deducted.
Because of he was standing beside the road, so there is no contribution and there is no evidence to that extent. There isn't any sort of contribution to the accident. That is the complaint.
This is the
Page
complaint.
25.
Page it starts at page 24, my lord. Yes.
Yes, yes. That is in the complaint. Also, kindly see page paragraph 3.
অধীন স্থানীয় তমলুক থানায় গত 2/7/20 তারিখে. Yes, usual. It's usual.
So
Whatever
the
happens.
COVID period is going on in 2020, and they have to also inform to the SP. Yes.
Yes, 3 and 5. Starts at page 29, my lord. Relevant portion is at page 30. Page 38, 38. Again, with the post-mortem, the medical legal case, which is at case report, which is at page 67, there is contradiction. This says there are a number of injuries, but the medical legal page 67, 67. That page 67, that injury report in the middle portion, it says drowsy and poor GLS. Yes, no other external injuries found clinically. And post-mortem says that there are a number of health. So there's contradictions. My lord.
On the date of admission, that report is there. That is the date of admission. And also quantum not under challenge.
হ্যাঁ, আমি জানি না কত দিয়েছে, 6 না 12 জানি না। I'm grateful, my lord.
Lordship, this is insurance appeal, minute.
But I need to appear on behalf of the respondent.
Yes.
Just call it accrued interest there on, otherwise they don't. No, sorry, act is what.
Every day you have to come and say the
Without,
same
without
thing.
Lordship, kindly pardon me if Lordship can say whatever, but Lordship cannot be.
Mr. Bonik, yes, yes.
Milord, this is insurance appeal is a death case, Milord. An award of nearly 17 lakhs has been passed. Milord, I have come up before your Lordship, Milord, on two specific grounds. The driving license of the driver of the offending vehicle was a fake driving license. Learned Tribunal just took note of that. In spite of that, Milord, in spite of considering the fact, taking note of that, Milord, the right to recover was not granted.
Right
And
to recover
right
was
to
not
recover.
granted.
And Milord, the monthly income of the victim, Milord, without any documentary evidence, was taken to be rupees 8,000 per month. It is an accident of 2018.
2018 December.
2018.
Lordship. And Milord, the victim was alleged
Right to recover was not granted.
was not granted.
But fake driving license was considered.
Was considered and proved.
Proved. Right to recover was not granted.
And Milord, the monthly income 8,000 per month was
He
considered
used to do?
on Milord, he was a vegetable
vegetable
seller,
seller.
and he is also alleged to be a micro insurance agent, whatever that is. But admittedly, no document, nothing came up before the court.
Did you file any cross objection?
No.
No, my lord.
You have received the money.
No, Milord, this is insurance appeal. The awarded sum is secured before my lord's court.
Where, show me that.
Lordship,
fake
Milord, the
driving
evidence of
license
Milord,
part.
the video, Milord, page number 13. Your Lordship will kindly come.
Page number?
13, Milord, of this paper book. Milord, running page.
These are all district.
Milord, running page 14, your Lordship kindly sees, Milord, paragraph 6, that we are claiming compensation of rupees 9 lakhs. Page number 14, paragraph 6. Milord, though I'm not on that, 9 lakh claimed, 16 lakh granted.
I'm asking
Milord,
you,
page number.
where was the opinion of the tribunal about fake driving license?
Milord, your Lordship will kindly come to page 32.
Now see, what is this? My husband was a vegetable businessman and LIC micro insurance
Lordship.
agent under Badwan such and such, and he used to earn 50,000, 15,000.
Lordship.
Okay, then what?
Then kindly come to page number 17, 17. Cross-examination, Milord. 6th line. My husband did not have any trade license. Not a fact that the statement of the vegetable lender is false. I will not be able to produce document to prove that my husband had received commission as
So
LIC agent.
to go and sit on the, I mean,
Vegetable vendor, but Milord, as far as
have trade
I
license.
understand. Milord, as far as the LIC agent part is concerned, Milord, I was on the very next line after that. I will not be able to produce document to prove that my husband had received commission as LIC agent. I do not have any document relating to prove the purchase of vegetable by my husband for his business. I do not have any document to prove that my husband used to earn rupees 15,000.
You show me that fake license part.
Lordship, kindly come, Milord, to page number 32 of Milord. This award starts at page 33. I was inviting my lord to page number 32. The last paragraph of page 32. Milord, this in this regard, OP number 5 has cited one witness, that is OPW1 Kamal Jana. Milord, this is from motor vehicle department, this gentleman.
Which page?
Page 32, Milord. I was, Your Lordship,
No, the evidence.
evidence, Milord, is at page number 24 of my Lord's paper book. Kindly come, Milord. Page 24.
Wait, I have appeared before the one. I have been authorized by such and such. This is my authority. The report submitted. I've brought extra copy of the.
Milord, 4th paragraph.
Such driving license.
I'm grateful to Your Lordship.
Of the person. The license number such and such is not tallying with our register.
And not the last,
Extra
I'm sorry.
details in respect of the said driving license number being computer generated. It is signed by our RTO license such and such. The extra details consider such and such. No such driving license in the was issued. Okay.
So my lord, it is so specific. My lord, my client cannot do anything more than this. My lord, these are the 2 points before your lordship, my lord.
Okay. Where is the part in the judgment?
Judgment, my lord, may I invite your lordship, my lord, to page number 32. The very last paragraph, my lord, it continues.
It in this regard of cited such and such, he had produced authority letter query. So,
It goes to entirety of page 33. It rolls.
driver is not. No, it has mentioned.
Yes.
The judicial pronouncements had made it clear that mere absence, fake or invalid driving license or disqualification of the driver for driving at the relevant time are not in themselves defenses available to the insurer against either the insured or the third party. To avoid its liability towards the insured, the insurer has to prove that the insured was guilty of negligence and failed to exercise reasonable care in the matter of fulfilling the condition of the policy regarding use of the vehicle by a duly licensed driver or one who was not disqualified to drive at the relevant time. It appears that there cannot be any shortcut method of proving the same. The witness who has come before the court to divorce brigade is an authorized person, is not the maker of the report. Conclusive opinion about the said license cannot be formed without the presence of the licensing authority, that is, Shri Vishwajit Mojumdar, who had submitted the report.
This is the finding, my lord, of the court. The officer of the motor vehicle department has come up, my lord, with the authority letter of his senior, and he says that why the senior did not come personally.
Okay. Prima facie, there is an impression.
And he says prima facie,
Wait,
this,
sir.
I'm sorry.
Prima facie, there is an impression that the driving license number such and such does not exist. Nevertheless, it appears that the said matter should be the subject of consideration before the appropriate forum in connection with appropriate litigation if undertaken by the insurance company intending to recover the amount payable to the claimants. It is a well-settled proposition of law decided by them that insurance should pay first and to recover if
Lordship.
you had been given.
No,
Yes. In view of the discussion held above,
Lordship.
may I not, it has been,
It's 33 last question.
in view of the discussion held above, it appears that though there is a prima facie indication regarding the fakeness of the driving license, no conclusive opinion about the matter may be passed in this case. Appropriate application before the appropriate forum is necessary in that regard, as such the additional issue number 1 is answered accordingly. Prior to that, wait, sir. Prior to that, it's a well-settled proposition of law decided by the Honorable Apex Court that the insurance company should pay first and to recover if there is any violation or contravention of the terms and conditions of the insurance policy on any ground inter alia, including the ground of driving license being fake. The dependents of the deceased should not be subjected to difficulty and starvation in a claim case under such and such on the ground that there is dispute between the insurer and the insured regarding violation or contravention of the terms of the insurance policy. It has been given. Maybe, it has been more elaborative and not a very
specific
concise, the specific one.
My
terms you wanted, that will be done because the evidence is there. Yes.
I'm not the monthly income part. Your Lordship will kindly come.
An incident of 2018, my lord.
$7,000 vegetable seven is not having. part of the government. 139. Milord, 139 is also insurer's appeal. Milord, in this case, award of 10,85,000 was granted in a death case. Milord, the ground of appeal, Milord, was that insurance company says that the offending vehicle, Milord, which was a truck, did not have, Milord, a valid route permit. But, Milord, here I am handicapped because, Milord, I have also taken a point of with regard to the monthly income of rupees 6,000.
Accident of which year?
2014, Milord. No documents were placed before the victim was the helper of a truck. Milord, 6,000 in 2014, Milord, I have taken this. That was the second plea, and the first plea, Milord, was there was no route permit of the offending truck. But, Milord, as I was stating, I am handicapped because I have not given any evidence with regard to that, Milord, with regard to the invalid route permit. The route permit was neither seized nor produced.
Yes, my lord, I am for the respondent claim.
It will take a little bit of time. If my lord takes up the passover matters, they will be, the stay matters, I have got the printout. Item number 11
12 and
to
13.
11, 12 and 13.
You have got that order?
Yes, yes, yes.
Give me. But then, সীমন্ত আসুক তাহলে উনি নিন। Sir, ওটা কে নিয়েছিল? চঞ্চল নিয়েছিল? চঞ্চল নিয়েছিল না? You show me that order?
Yes. This is for the first matter, item number 11. And the challan is already. My lord, I'll come back.
So, take it. আজকে তো অরিজিনাল remaining matters.
Lordship.
How many are there where Mr. Ashik Mondal and Shubhankar Mondal are there?
With me, there are none.
So,
with me, there are
With me, Milord, no, with me also there are none. Milord, at 2 o'clock, Milord, we have got some matters before Honorable Division Bench with workmen.
you come back. I
Milord, yes, it's
fear.
taking up those workmen compensation matters. Milord.
Where it is
Lordship,
after
Lordship.
doing
No, দুটো সময় on April side আছে. Milord, yes, Milord. After that, I'll come back. Definitely.
because
Yes.
till 160 we will finish it off today. If it is 6, 7, 8.
Tell me. But what about the others?
I shall talk. I will proceed to Lordship. The other side, get to proceed. Any other game?
Sir, can you ask any one of your juniors to be there because the staff of the appellate side is not sitting here?
Can you
Yes, it can. Okay.
Vigilance side matter. I didn't know what.
But I'm for the petitioner.
My lord, I am for the respondent, my lord. My lord, in this matter, may I pray for a short indulgence, my lord? My lord, the claim of the
You did not file the affidavit in opposition.
my lord, the claim of the petitioner has been conceded by the respondent corporation, my lord. I have received a soft copy of the communication just now, my lord. I'm yet to receive the entire communication, physical communication, my lord. My lord, thereby I'm praying for a short indulgence for only, my lord, 2 days so that, my lord, I can produce it before your lord.
If
I've
that be
also
the case, your problem is resolved, my lord. The learned advocate representing the respondent corporation submitted that the grievance of the petitioner appeared to have been addressed by the concerned corporation. She intends to file a formal application to that effect and sought for further time. Next date be fixed on 29th of August.
Well,
No. Yes. If I may. Answer. None appeared to represent either of the parties. Next date be fixed on 2nd of September as last chance. Next. None appear to represent.
Sir, I am for the appellant. I have prepared the written notes of us. Let make it 5 minutes passover. I mean, in that building, let us running.
Next.
163. 163.
Juncture. None appear to represent either of the parties. Here we go. Next.
My lord, I am for the statement.
None appear to represent the appellant. The learned advocate representing the state is present. Madam, did Mr. Panda submit?
Or Mr. Panda is engaged. Yes, madam. He has came.
এটার পেপার বুক আছে না?
Yes, madam. Paper.
Next. Ashok.
This is the written notes of argument. Look, one thing I submit before your look, the conviction under section 324. Look, 324. Look, there is an alternative that substance or fine. Look, so look, if your lordship so pleases, look, kindly convert this thing on that. And look, the one thing, look, the learned trial judge in his entire judgment, look, he not spend any word regarding the 360 of the provision, 360 of the Code of Criminal Procedure. But it is the mandatory to have annexed one judgment of the Supreme Court, where the Supreme Court categorically stated that if you not desire to give the facilities under 360 to the appellant, you should mention this thing. That for this reason, this has not been given. And I have relied upon two judgments, one of the Supreme Court, and relying upon that judgment, this honorable court granted in similar situation, granted probation of the person. The persons before your lordship, they are all 65 years, 72 years old. The incident took place in the year 2002. By this time, 23 years had been elapsed. So, I am praying, I have an arguable case. The doctor, PW7, categorically demolishes the prosecution case because of the fact the prosecution case is that this person is assaulted by a dog. The doctor categorically stated there is no sharp cutting injury. The injury all are blunt weapon. As such, this doctor's evidence and the ocular evidence of the prosecution witnesses does not match. So, all of this, your lordship heard this matter earlier. I have given.
Okay. You can conclude it.
But I am deep.
None appear to represent the state borough. 166.
Mr. Ronnie Mitra is appearing on behalf of the respondent, my lord. I am praying for short passover, my lord.
166.
So they have given a charge sheet in this matter. So now the charge sheet, but the whole charge sheet is on the basis of a statement of a court. It is stated that the co-accused have stated XYZ things against me, and that's why they are relying on two things, very important. But one is the CFSL report, which get not with them. They say with the judge.
Quashing for, you have come for quashing?
Yes, I have come for quashing of check. There was a warrant of arrest initially against me for section 3 of the RPUP Act. And I am an engineer of the railways. But initially they had issued a warrant proclamation attachment together, but I had challenged the whole proceeding, including that order, before this honorable court. And this honorable court heard and stayed the warrant. In the meantime, your lordship was in session of the matter. Your lordship gave them liberty to file a charge sheet if they wanted. But they had filed a charge sheet before your lordship. But your lordship was pleased to give me a copy of the charge sheet. But I have gone through the charge sheet. But now I want to make submission on the merits of the charge sheet. But as to why the charge sheet which has been filed against me does not hold water at all. They are relying on three things. If I may just sum it up. One is a co-accused statement, which is not admissible in evidence. Two is, my lord, a report from my authorities saying that whether there is a shortage of material in that place where I was employed. That report is not
What
with
were the charges against you?
Section 3. Section 3 of the RPUP Act. Well, that in official capacity of being an engineer, I have abetted or I have ensured that those articles of railways are stolen or theft. Nothing has been recovered from my possession. It's an admitted situation. The recovery also happens from somewhere a distant place from where my place of office is. Whatever they have, if your lordship so want, I'll place the charge sheet by part. All people whose statements are taken to implicate me are all accused persons. And they have separate two things else. One is the CFSL, one is the stock register report. None of them are with them. They said in the charge sheet that they're awaiting that. They're awaiting the stock registers report and they're awaiting the CFSL report of the materials which they seize. These three things are there, my lord, based on which the charge sheet is filed. If the lordship so allows me, I can file an exception to the charge sheet or an opposition to the charge sheet.
Your lordship. No, I just had. You had been given it to for perusal itself, but not at this stage. Yes.
Your lordship has already tried enough on the last occasion to direct my learned friend to file an affidavit.
No, that affidavit. I will not lie. Affidavit a corrigendum take devar jonno diyesi, sir.
Yes. You have produced a paper, sir.
No, what is it called?
Yes.
To the corrigendum issued by the opposite party number 2 Eastern West.
Yes.
It has got nothing to do with the charge sheet.
Very relevant, my lord. Why I tell you, lord?
No, this corrigendum is not
This is the corrigendum.
related to the.
Why the corrigendum is important? But I was subjected to a departmental inquiry by the railways. So, what happened in the conclusion of the departmental inquiry? The order says charge not provided.
This is that matter in which you are saying that you had been exonerated.
Yes.
And contrary to the.
I had played.
That is the reason your lordship has been pleased to direct to ascertain this collegium. An affidavit has to come from his end. And today my learned friend is supposed to file that affidavit.
But I had given the full document relating to a departmental inquiry, and the last page of that affidavit, I filed an affidavit.
Allegation against noting
of charge not provided. It was not. This my lordship will not get to the file. Lordship sees this from my file only. Lordship sees the departmental inquiry concluded by writing articles of charge not provided. So my learned senior friend had raised an objection that it is not proved, is not there, not provided is there. So I went back to the department. I said, this is what is being surfaced. It should be not.
There was a typographical error.
So the corrigendum was published because of that clarifying the typographical error. So lordship, when I had placed it on the last occasion, lordship gave me liberty to bring that on affidavit. But
there's no scope because you were harping on the fact that the order said that articles of charge has not been proved,
Yes, my lord.
then
The department, my
Then
lord, the
there
auditor-
must be a final order, my lord, subject to
That is
correction
not
from
final
your
order,
lordship.
my lord.
No, that is not a final order.
If the department.
Let him file affidavit, I will file exception.
If the
I have
departmental
instructions.
inquiry concludes by stating that articles of charge not proved,
No.
but what else can be a final order? But it says article of charge
No.
against me is not proved.
It is not written here, neither here nor there.
But that's why the corrigendum came in, my lord.
so it has been issued by the Eastern Railway itself.
Yes, my lord. My
The
lordship
lordship-
is the signing authority.
If my learned friend allows me, then I can submit one thing.
You do one thing.
Yes.
You have received this corrigendum.
Yes, my lord.
You give a copy
No, I
to
definitely
him.
give a copy to my learned senior.
Let him get a clarification on this.
Absolutely.
You give a copy to him. Let him get a clarification.
Then
If
what
he's
should I
not,
hand over this copy to him, or should I file an affidavit and give a copy to him?
you file an affidavit. Give him a copy.
Yes.
And my lord, subject to correction, he has to add in the cost
If
title
you
of,
are banking upon this document,
Yes.
you file it in the form of an
My lord.
affidavit and give him a copy. Let him file an exception or seek clarification.
Well, I'll give it an advance
and
copy.
one indulgence I'm paying, my lord, he has to add, I will give the name of the disciplinary authority, because here, let me, sir, if you allow, here, my lord, the allegations is theft against him. Now, the authorities who are, my lord, filed the charge sheet are not the disciplinary authorities who are holding the disciplinary proceeding against my learned friend. They are they
Step by step, let
Very
him first do it,
very
thereafter.
very good.
Let us see what is your opinion on this,
Yes.
right? Then you will,
I will file an exception. Let him file. I will file.
along with the reasoning,
Yes.
along with the reasoning.
My lord. That is your lordship.
You should have done it earlier.
Yes.
I apologize, my lord, there was some delay on my part. I might just certificate and definitely.
The learned advocate representing the petitioner has placed a copy of the corrigendum relied upon by him, claiming to have been issued by the opposite party number 2 Eastern Railway, stated 30th of December 2024.
Opposite party number 2 is, my lord, Inspector of Railways Protection Force. When he files a complaint against me, my disciplinary authority is not opposite party number 2. My disciplinary authority is my.
But then on
appointing
the earlier occasion, you had mentioned that.
My lord, it's Railways is a department.
Respondent Eastern Railways, opposite party number 2 ticket. Respondent Eastern Railways. He is to file the
My lord, senior
said
divisional.
copy of the corrigendum placed before the court today in the form of an affidavit on the next date of hearing, serving a copy of the same upon the learned advocate representing OP number 2 in advance.
My lord, only one thing I can submit. The paper which has been handed to you by my learned friend, my lord, here has been written the disciplinary authority. My lord is senior divisional engineer. Coordinator.
Sir, let him file.
Yes, yes, very well.
Thereafter,
I
seek
just
clarification.
Yes, very well.
Next date we fixed on 19th of September.
আমাদের তো
167. Yes.
But 167, I had mentioned this, my lordship. Remember this, my lord, Rathi, my lord, Rajendra Rathi, my lord. It's a was a dispute between two parties, but I challenged the FIR. Where Mr. Sinha was appearing for the state, my lord. In the meantime, my clients have gathered that a charge sheet has been filed in respect of that same matter. But my clients have instructed me only to withdraw this matter, but praying for a liberty from your lordship to file afresh along with the charge sheet. Because I want to challenge the charge sheet. Because initially I had challenged the FIR, and as there was no stay from this.
Now this ultimately the presence of that person could not be traced out.
State has, IO has not done that.
A charge sheet has been submitted against him also, your lordship. And we are for the private opposite party de facto complaint. We are appearing before the learned court below, and we have preferred already a Naraji application against that charge sheet. Mr. Shobhashachi Banerjee is leading us in this matter.
Then where are your seniors? I asked one of your seniors to mediate.
He got disinterested.
The learned advocate representing the petitioner. Filed a written instruction on behalf of his clients, being the present petitioners, to withdraw the instant writ petition. Sorry, instant criminal revision. Instant criminal revision being number 3467 of 2023. Which was filed for stay of the proceedings.
And preferred for quashing of the FIR. And interim
Quashing of the FIR. However, it was further submitted by the learned advocate representing the petitioner that the charge sheet in the GRS case number 947 of 2023 has already been filed, and in the changed circumstances, they intend to withdraw the instant criminal revision application with a liberty to file a fresh revisional application, and the same is allowed. The written instruction placed by the learned advocate representing the petitioner be kept on record. Under such circumstances, the instant revisional application being 3467 of 2023 is withdrawn. Stands withdrawn with the liberty to file afresh. We cannot dismiss it. Next. Stands withdrawn. আর কিছু আছে পাঠার কোনো 2 PM ফিক্সড আছে?
This is the execution case, that order, my lord. The last paragraph.
Sanchit? The learned advocate representing the appellant insurance company has placed an order filed by the learned court of additional district and sessions judge come MSc tribunal FTC 2 Alipur Sir 24 Parganas dated 8/8/2025 in connection with MSCC execution number 61 of 2025, wherein the next date has been fixed on 21st of August 2025. Let the copy of the order as aforesaid be kept on record. In view of the appeal being FMA, a number to have filed by the appellant insurance company, the proceedings of MSCC execution case number 61 of 2025 be stayed for a period of 4 weeks. Did I give you the next date?
No, my lord.
Next date be fixed on 25th of September. Prior to that, you serve notice.
I'll do all the.
And then if you
I'll deposit also.
If you are to prepare the paper book, do that also in the meantime.
My lord, I shall. I'm grateful.
This
next two matters same.
Same.
These it's a challan, copy of the challan and the order. 12 ওটা 12 দিয়েছি
ওটা তো আগেই বলা হয়ে গেছে।
আর এটা 13
তুমি আগেই সকাল
four weeks.
serve notice and
Yes.
file affidavit of service.
And I'll also deposit, my lord.
4 weeks within 4 weeks.
My lord, grateful, my lord.
13 also
13 same,
is
same. I'm deeply obliged, extremely grateful. Only the execution case number will change.
ওই অর্ডার শিটের কপিগুলো
Well, earlier we have seen, Milord, we have covered the factual aspect, as I told you, Lord. What remains for Milord, scrutiny by Lordship, Milord, is the decision-making process. Milord, after all, Milord, as a writ court, your Lordship is concerned with the decision-making process. Now, the decision-making process has got two facets. First of all, Milord, we shall see the extreme hurry and the, Milord, the unseemly, Milord, haste followed by the department in holding the record of evidence procedure. Milord, record of evidence is very material because it took place immediately after the incident when the evidence was recorded. And later on, Milord, this record of evidence form part of the main proceedings before the General Security Force Court. So, it is a material which was used against me. Now, Lordship says, Milord, this record of proceedings was held. It started in hot haste on 12th September. I think these facts are all admitted. I don't have to draw lots of attention, Milord, to particular provisions of the, to particular, Milord, the entry in the records, Milord. 12th September it started, Milord. Incident took place on 10th September, it started on 12th September. And on 12th September, Milord, my medical condition, Milord, will be apparent from the medical report. Lordship kindly turns to Milord, page 73.
So you are again going to the facts, sir.
Only, Milord, only this for the purpose of, Milord, in support of my argument. No other facts will be placed before your Lordship.
Which page?
Page 73, Milord. And Lordship gives me a minute. Record of evidence to
Page
Page 78. Page 78. 78. Milord, this is the evidence of Bharati Sen, Dr. Bharati Sen, who examined me.
Page 78
Of them, complete page. Milord, page 78, Lordship comes to the middle page. Milord, I will not trouble your Lordship with the entire.
The witness points out.
The accused was not admitted in CI Kodumtala and brought back to the advice of psychiatrist NBMC, North Bengal Medical College. Accordingly, Dr. Behara saw the accused on 12th September and advised to keep the patient under close observation for a week as the head department was away. Accordingly, kept the accused under observation from 13th September to 16th September. All these days, Milord, the record of evidence was in full swing. As per my observation, on 13th and 14th September, this is my physical condition, mental condition, the accused was depressed, shows slow speech, abnormal belief that someone will kill me. Sometimes I was confused, insomnia. Milord, under the fear that someone would kill him. This is the effect of depression. On 15th September, irrelevant talk, and then 16th September, not talking with anyone. The pulse rate of the accused remained 100 on above on all days, which is a case of tachycardia. As per my observation, I prepared the observation report of the accused, I hereby produce the said observation report before the court. Now, my lord, Dr. Behera's evidence is at page 17, my lord, briefly. Dr. Behera, because, my lord, he was treated on the advice of Dr. Behera. His evidence, he is a psychiatric expert at page 70. Dr. Bharathishan refers to Dr. Behera, my lord. Page 70, my lord. My lord, the last paragraph. He is the first witness for the defense. Page 70.
Yes.
Dr. Nirmal Kumar Behera, etc. Next paragraph, my lord. I have been serving as Associate Professor in Department of Psychiatric, North Bengal Medical College Hospital. I did my MD Psychiatric Medical Specialist from Kolkata University and PhD Psychiatric from North Bengal. I am also internal examiner MD Psychiatric. He is a specialist. Now, my lord, what he says, next paragraph, page 71, my lord. There is a prescription. My lord, middle of the portion. 0.7 days rest. Has your lordship got it, my lord?
Yes.
0.7 days rest advised by me means complete mental and physical rest. My lord, these words speak for itself. Mental and physical rest. In such depression cases, we advise not to handle firearm as it can be dangerous to the patient as well as other because the patient may have suicidal or homicidal thoughts. For the same reason, they advise him to be kept in close observations. Generally, in severe depression, judgments, attention, concentration, my lordship will kindly, my lord, allow me to place emphasis on these words. In severe depression, judgment, attention, concentration, reasoning of patient keeps low, keeps slow. That is to say, thought process of the patients will be low. Thought process will go haywire, in my humble submission. But there's the medical advice, my lord. Now, my lord, logically turns to, my lord, the Border Security Force rules, Rule 45, record of evidence.
Rule 45.
Rule 45. 48, my lord, I'm sorry. Rule 48, record of evidence. Rule 48.
Yes.
Why I'm showing it, my lord, logically says, my lord, what was the, my lord, safeguard available to me if the record of evidence was taken under normal circumstances, and how, my lord, I was deprived of the benefit of the safeguards, my lord, resulting in failure of natural justice. My lord, logically says the officer ordering the record of evidence may either prepare the record of evidence himself or detail another officer to do so. Next sub-rule is important. The witnesses shall give their evidence in the presence of the accused, and the accused shall have right to cross-examine. So this right of cross-examination, and need hardly tell you, lordship, lord, could not be effectively exercised by me, who gave the evidence against him, because of this extreme hurry. Now it's material in this connection, we have to point out.
Now, sir, the petition, according to you, the petitioner refused to cross-examine
not
or
refused.
was not in a position
Not
to
in a position, because the cross-examination made by me is perfunctory. Perfunctory, my lord, he is not in a position, lordship knows, my lord, these words, my lord, judgments, concentration, my lord, all
But
these
did
words.
he at all cross-examine?
He did, my lord. He made a very feeble attempt to cross-examine, but the point, my lord, that I am humbly and canvassing it before your lordship is, had it been done under normal circumstances, the safeguard in this rule could have been, my lord, given full play. He was, my lord, not in a position to fully avail himself of the benefit of cross-examination because of his mental condition. He was incapable, my lord, so to say. Well, cross-examination is not a very simple thing, my lord. It is for exonerating himself, you know, part of the judicial process. Now, my lord, he could not do it. Then lordship turns to Rule 51A. had the cross-examination, Milord, been done in proper, because it is to be remembered here, only one thing is very material. Milord, this record of evidence started in 12 September, but it was concluded in October. But in September itself, during these few days, Milord, from 12 to 18, 5 material witnesses, the principal witnesses for the prosecution, were all examined by me. And Milord, in October, only other witnesses are left. But the material witnesses who were, Milord, instrumental in proving the charge, their evidence was over within the span of, Milord, few days in September itself. Now, Milord, Lordship sees Rule 51A. What happens after the record of evidence is prepared? Where an officer has been detailed to prepare the record of evidence or abstract thereof, he shall forward the same. The officer taking the record forward the same to the officer or authority who ordered for its preparation. Then that officer or authority, Milord, sub-rule 3, Milord. The officer or authority mentioned above, after going through the record of abstract of evidence, including additional, may dismiss the charge after recording reasons therefore. He could have dismissed the charge, Milord, had I been in normal condition and fully able to cross-examine, or may not. Sub-rule 3.4, apply to a competent officer or authority to convene a general security force court. So, Milord, either you will dismiss the charge or you will, Milord, recommend the convention of a general security force court. He did the last. Because, Milord, there is nothing on record, Milord, where I could, Milord, effectively put forward my case. So, this is the result of extreme hurry, Milord. This is what I am. Now, Milord, Rule 59 is also material. At different stages of examination of record of evidence, it doesn't end with the officer who examines the record of evidence. It goes to the higher authority. Rule 59. Action by superior authority on receiving an application for convening a court. There also when the charges are examined and the matter is gone into, Milord, in details. As soon as a superior officer receives an application for convening a court, he shall scrutinize the charge and the evidence against the accused where necessary in consultation with the law officer, and he shall direct the commandant to dismiss the charge. So here also, Milord, there is a scope for dismissal, which I couldn't avail because of my incapacity, Milord, in contribution of medical evidence. Next, Milord, this comes to, Milord, takes us to the end of this, Milord, the extreme hurry leading to denial of natural justice. Then, Milord, Lordship looks at the other aspect of the decision-making process, complete negation of the act and the rules. Why I say so, Milord? Lordship turns to Rule 116. Before that, Milord, Rule 98. Rule 98. Now, Milord, incidentally speaking, Milord, I will humbly submit that all these rules in disciplinary proceedings, Milord, having a penal flavor or leading to penal consequence should be strictly construed by Lordship. Lordship will not, Milord, countenance any infraction or any deviation from these rules. And, Milord, will call upon my learned friend to prove before a Lordship, satisfy a Lordship as to how these rules are complied with. Now, Milord, Rule 98. Deliberation and finding. The court shall deliberate. Well, this is, Milord, the procedure of the General Security Force Court. Milord, the chapter heading speaks for itself. 98. The court shall deliberate on its finding in closed court in the presence of the law officer. Then, Milord, next, very important, the opinion of each member of the court as to the finding shall be given by word of mouth on each charge separately, starting with the junior most in rank. 5-member bench. So they should deliberate on finding. That means hold consultation on themselves. And, Milord, opinion of each member of the court should be ascertained. 99. The court shall Well, there must be a record for this. Rule 90.
Yes, sir. Rule
Rule
98.
98, my lord, must be borne out from the record, my lord. The note sheet will speak for itself. Now, when my nullifying stand comes, my lord, and will point out to your lordship how Rule 98 was complied with. Then, my lord, this word deliberation also occurs in Rule 126D.
So prior to that, you mentioned Rule 116.
Yes, Rule 116, I am going to. Before that, my lord, I end with Rule 126D, where the word deliberation also occurs. Deliberate. This has got a link with this.
Rule 1 to
26. Rule 126. Power and duties of law officer. And then, my lord, it says, where a law officer has been named to act on the court, he shall, my lord, A, B, C, give his opinion, etc. D, sum up the evidence and give his opinion on any question of law before the court proceeds to deliberate upon its finding. Before the court proceeds to deliberate upon this finding, that means, my lord, law officer, my lord, law officer's role, though frankly speaking, it belongs to the prosecution. But, my lord, if your lordship looks at the entire scheme of the act and the rules, here almost the law officer, my lord, acts, it's supposed to act as an independent authority or almost as an amicus curiae. In effect, what it did actually do not know. But the question is, my lord, here the rules provide that he should give his opinion on any question of law before the court proceeds to deliberate upon its findings. So, deliberation of the findings cannot be dispensed with. And that it has not been dispensed with, the record will speak for itself. Then, my lord, Rule 116. Taking of opinions of members of court. This is another very vital rule. My lord. Taking of opinion. Every member of a court must give his opinion by word of mouth on every question which the court has to decide, and must give his opinion as to the sentence, notwithstanding that he has given his opinion in favor of acquittal. So the words are very material, my lord. Give his opinion by word of mouth, very well, by word of mouth, on every question which the court has to decide, and must give his opinion as to the sentence. So on the question that the court has to decide on all the issues, and then also on the sentence by word of mouth. The opinion of the members of the court shall be taken in succession, beginning with the member lowest in rank. So how it was given and how it was taken, that, my lord, we have not been able to find any reflection in the records. My learned juniors have taken inspection of the records. There is nothing in the record, not a single line, my lord, in the note sheet or in other parts, in any other document in the records. My lord. How Rule 116 was complied with, how Rule 98 was complied with, or whether complied with at all. Now, my lord, in the absence of any material in the rule, my lord, your lordship, my lord, will have no material to decide that they were complied with. My lord, the judicial scrutiny means how these rules are complied with. So if the judicial scrutiny, my lord, is not possible to be held because of total absence of the records, so this will amount to a grave infraction of the rules, my lord. And this will tell upon the ultimate, my lord, the justice, I mean to say, the entire process of, my lord, the judicial procedure followed, my lord, resulting. Because these rules, my lord, as I once more may repeat, my lord, these are very penal in nature, should be strictly construed. My lord, why this is so material, my lord? This is spelled out, my lord, in a section of the Act, my lord. My lord, this section of the Act is to be read in conjunction with the rules. My lord, this section is, lordship kindly comes to me, lord, section, I believe it is, section to the court. Yes, the section is section 86. 86 of the General Security Force Code.
Voting by members.
Section 86. Your Lordship looks at section 86, voting by year, voting by members. Another mandatory provision, Milord, cannot be given a go by. Subject to the provisions of subsection 2 and 3, every decision of a security force court shall be passed by an absolute majority of votes. As your Lordship does, Milord, when your Lordship sits in, Milord, in larger benches, by majority of votes. Who has voted for? This is a 5-member bench. Nothing on record, Milord, not a single line as to how the voting procedure was going. Was it 4:1? Was it 3:2? Nobody knows, Milord. Whether I was, Milord, held to be, Milord, not guilty of all the charges by 4:1. And, Milord, the conviction, Milord, is confirmed, Milord. I mean to say the conviction in the sense that these rules were totally, Milord, given a go by, totally disregarded. Because the final judgment is not signed by all the members. The final judgment carries the signature of only the presiding officer and the law officer. As if Milord, law officer was also part of the Milord, the General Security Force. But be that as it may, Milord, I am not on that. The judgment is not signed, so therefore there is nothing to before your Lordship. Had the judgment been signed by all the members, Milord, your Lordship could have come to the conclusion very well. It is an unanimous judgment. All 5 members have signed. That means, Milord, voting in favor of the acquittal or exoneration, whatever it is. So whose judgment it is? How they have arrived at this conclusion, Milord? In total violation of the rules and the act. Don't the rules are, we have heard of military justice. Here, of course, it is paramilitary justice, BSF. Milord, this is the position before your Lordship. Now, after this procedure is over, then you come to the question of punishment. And punishment also, Milord, is another facet where, Milord, I think there is a total deviation from the, and is severely faulted. I mean to say, the very exercise of the power of punishing me. What they have done, Milord, they dismissed from service and also imposed an imprisonment for 6 months. Lordship knows, Milord, under the BSF Act and rules, Milord, they are maintaining an in-house prison, and a BSF personnel, Milord, who is punished, Milord, who is given a sentence of imprisonment, can be kept in their own domestic jail. So I was kept in their own domestic jail for 6 months. And I can tell you, Lordship, Milord, even after the expiry of 6 months, I was not released. My wife, when I mean the petitioner's wife, had to come before this court and file a petition and obtain an order from this court for his release. I think it's a case of habeas corpus or something, Milord, I do not know, because I did not come. I came at a later stage when this writ petition is moved before Justice Talukdar. Before Justice Talukdar, I came at that stage, Milord. Before that, proceedings took place, Milord. Be that as it may, Milord, Lordship looks at the charge under which section the charge has been framed. Which violation of which section is stated in the charge. That is page 61. 60 or 61. Page 60. 61 is the General Security Force Code member's name. Yes, 60.
Section 40, section 46.
Section 40. Section 40. They are complaining of infraction of violation of section 40.
But he had been exonerated from one?
On the other section, Milord, first charge.
46.
That is, no, that is, Milord,
40.
section, no,
If
that
40
is,
is...
He was exonerated under section 307, attempted murder. Milord, Lordship looks at page 60. Page 60 speaks for itself. Page 60, first charge. They mention, Milord, first charge is
307.
307. That is attempt at murder. He was exonerated. Then
The
second
section 46 of BSF.
46 T. Yes, my lord. I'm
So
placing
if you come to page 60,
yes, section 60.
first charge, BSF Act 1968, section 46.
Section 46.
Committing a civil offense.
Civil offences.
That is to say, attempt to murder punishment punishable under section 307 IPC. Yes.
Well, they could have, well, the act provides that they could have sent me for being prosecuted in the criminal court, or they could himself hold the criminal trial. Well, they decided to hold the criminal trial themselves and then totally acquit me. Second charge is section 40. The charge says at about 14:24 hours on 10 September, unauthorizedly took in such rifle butt from Constable Gajendra Singh, who was detailed as escort with gypsy, etc. So the charge is, Lordship will strictly construe the language of the charge. Unauthorizedly took, nothing more, nothing else, nothing less. Unauthorizedly took a rifle. That's all. That's the charge. That constitutes the sum and substance, the gravamen of the charge.
No, it says violation of goods order and discipline.
That's right. Violation of obliged to Lordship. Section 40, Lordship looks at section 40 of the BSF Act. Any person subject to this act who is guilty of any act or omission which, though not specified in this act, is prejudicial to good order and discipline on the force, shall on conviction by security force court be liable to suffer imprisonment for a term which may extend to 7 years or such less punishment as in this act mentioned. Lord, where is this, Lord? Punishment of dismissal from service. I'm asking the question to myself, and I shall cite case laws on this. What they have done, my lord, they have purported to proceed under section 48. Section 48.
Where
I
is it
think, my lord,
mentioned?
section 48.
Where is that mentioned?
There nowhere it is mentioned, because in section 48, my lord, your lordship will find the punishment of the power of dismissal. Power of dismissal is contained in section 48, not in section 40. The section under which I was charged, my lord, doesn't contain the power of dismissal. Lordship can look at section 40, compare it. Punishment may be inflicted in respect of offences committed by persons subject to this act and convicted by security force courts according to the scale following, that is to say, death. Imprisonment which may be for a term of life or any other lesser term, but excluding imprisonment for a term not exceeding 3 months in force custody. Then C, dismissal from service. So what they have done, my lord, they have, according to me, if they have invoked section 48, or if section 48 is in their mind, so they have imposed a punishment of 6 months imprisonment that might come under section 40. 6 months imprisonment. Lordship can see, my lord. Section 40 says 7 years or less punishment. Very well, section 40, I can understand. After all, the punishment has to be found out somewhere. And then dismissal from service, section 40 doesn't, my lord, allow them to dismiss somebody from service, only imprisonment. So here, my lord, frankly speaking, two interpretations are possible on the question of punishment. Whether, my lord, they could invoke section 48 as well, or they are confined to section 40. This question, lordship will kindly decide after hearing me. Before that, my lord, I shall come to this, my lord. Section 49 and 50, lordship can looks at for just scrutinizing, and lest it be said that we have not looked at the entire provisions. Subject to provisions of this act, a security force court may, on convicting a person subject to this act or any other offences specified in section 14 to 45, I come under 40, award either the particular punishment with which the offense is stated in the said sections to be punishable, or in lieu thereof, any one of the punishments lower in the scale set out in section 48, regard being had to the nature and degree of the offense. Milord, how is this section, Milord, to be seen, Milord, in the context of the punishment? Award either the particular punishment with which the offense is stated in the section to be punishable. That means how the offense is stated in section 40 to be punishable. The plain and simple meaning is this. Or in lieu thereof, any one of the punishments lower in the scale set out in section 48, regard being had to the nature and degree of the offense, or in lieu thereof, any one of the punishments. Any one. Either you proceed under section 40 or any one of the punishment in section 48.
That is combination of punishments.
Combination not permissible. Not permissible.
But sir, section 50 said so.
I'm coming to that section 50. Let's see, Milord, section 50, Milord. How is section 50 applicable? Therefore, Milord, I'm grateful to your Lordship for pointing this out. But I am also going to place section 50. Combination of punishment, but the heading is, Milord, in my humble submission, misleading. Because it doesn't apply to all the situations. A sentence of a security force court may award, in addition to or without any other punishment, the punishment specified in clause C of subsection 1 of section 48, clause C, subsection 1 of section 48.
It is dismissal from service.
And any one or more of the punishments specified in clauses E to L. So clause C, if they impose, then it must be combined with any of the other punishment in E to L. Lordship can look at E to L, speaks of nothing else. E is, Milord, I think the rules make no sense. If I am dismissed from service, then what is the question of punishing me under E? E says reduction in the rank or to a lower rank or grade. If somebody is dismissed from service, then what is the question of reducing him in rank? Then F, forfeiture of seniority of rank and forfeiture of all and any part of the service for the purpose of promotion. Then Milord, G, forfeiture of service for the purpose of increased pay, pension, any other. So somebody is, Milord, it gives him the power to combine. I'm dismissed for service, then Milord, they're imposing me the punishment of, Milord, reduction in rank, forfeiture of seniority, withholding of pay, all these things. And Milord, if they want to combine, Milord, apart from the question of Milord, the total, I should say, absurdity of the rules, Milord. If they want to combine, very well combined as per the rule. It says that if you impose the punishment in clause C, that is dismissal, then any of the other punishment, E to F, which does not speak of, Milord, imprisonment. So, Milord, if these rules, Milord, I think I've been able to, Milord, place all the rules, or should I go through it once more, Milord? Should I go through the rules once more, Milord? Rule 4950.
No,
to, Milord, clarify my argument. No. Now, Milord, if there is any scope, your Lordship believes that these rules, having, Milord, very severe penal consequences, are capable of two constructions, then which construction is preferable?
Yes, sir.
Then which construction will be preferable, Milord? One rule says, one construction says, Milord, authorizes them to impose the penalty. Milord, another construction, Milord, totally exempts me from penalty. So in a similar situation, what is to be done? Milord, I would like to, Milord, place before your Lordship a Supreme Court judgment, Milord, governing a more or less instruction, Milord, interpretation of section. আমার কাছে আছে সিনপসিস তো আছে দেখাবো তোমার কাছে এনো মিসপ্লেসড হয়ে গেছে প্রবলেম ডিসপ্লে but we're going to look at 1954 1 SCC 961 1954 1 SCC 961 Milord, before I proceed further, Milord, I must clarify before your lordship that I am proceeding, Milord, to cite these sections without prejudice to my other argument. That, Milord, the procedure followed by the General Security Force Code and the punishment itself, Milord, is in total negation of the act and the rules. So, if your lordship is, Milord, satisfied, Milord, then the court may not proceed any further. But still, then, Milord, all these questions, Milord, are to be closely examined. Now, Milord, 1954 1 SCC 961. Lordship kindly turns to Milord, page 963, the head note. And then I'll come to the provision, head note. Head note also, Milord, sums up. 963, Milord, last head note. Interpretation of statutes. Particular statutes are provisions. Penal statutes are provisions. Mode of construction. Possibility of two reasonable constructions. Construction in favor of exemption from penalty must be given effect to. Language used in the provision must not be stretched to carry out the legislative intent. So, Milord, it is self-evident that the construction in favor of exemption from penalty, Milord, this has been further explained in the judgment itself, Milord. Lordship comes to page 967, paragraph 8. Paragraph 8. I'm placing this paragraph, Milord. The question, it about the three, Milord, it is very material that this is a 5-judge bench judgment. Justice Mohajan, Justice B.K. Mukherjee, Vivian Bose, N.H. Bhagavati, and T.L. Venkatarama Iyer. I mean, all the stalwarts in the early days of the Supreme Court. Milord. Paragraph 8. The question, the 5-judge bench judgment. The question that needs a determination in such a situation is whether Section 18(1) makes punishable receipt of money at a moment of time when the lease had not come into existence and when there was a possibility that the contemplated lease might never come into existence. This is a fact of the case. It may be here observed that the provisions of Section 18(1) are penal in nature, and it is a well-established rule of construction of penal statutes that if two possible and reasonable constructions can be put upon a penal provision, the court must lean towards the construction which exempts the subject from penalty rather than the one which imposes penalty. It is not competent for the court to stress the meaning of an expression used by the legislature in order to carry out the intention of the legislature. As pointed out by Lord Macmillan in London, Northeastern, etc., where penalties for infringement are imposed, it is not legitimate to stress the language of a rule, however beneficent in its intention, beyond the fair and ordinary meaning of its language. Now, my lord, the fair and ordinary meaning of Section 40 is plain and simple imprisonment. Fair and ordinary meaning of Section 40 is, my lord, imprisonment, 7 years or less. Doesn't speak of, my lord, dismissal from service. That power is not given under Section 40. My lord, this is the sum and substance, my lord, of this. This is the, my lord, ratio of this court, my lord. So, if your lordship is of the view that two interpretations, that two reasonable constructions are possible as to the applicability of rule of Section 40 and Section 48, read with Section 49, 50, etc., then, my lord, the section which plainly tilts the balance in favor of exemption from punishment, that section will appeal, that interpretation will appeal to your lordship and not the other interpretation. Now, my lord, the next case, my lord, will be a single bench judgment of the Milord Orissa High Court. Milord, this is a judgment, Milord. I had a copy that, it is not reported. I'm going to copy. Of Justice S.K. Panigrahi, Milord. The judge সাহেব কে দিন আমি দিচ্ছি কপি দিচ্ছি এটা দিয়ে দিন জজ সাহেবকে Oh, I see. N. Milord, here the facts are more or less similar. I tell you what happened, Milord. This is a CRPF constable. I was a BSF officer and he was a CRPF officer, Milord. Or whatever it is. He suffered from depression and he was, Milord, dismissed from service. Now, Milord, Lordship looks at page 2, Milord. Page 1, it starts. The petitioner attempted suicide on the ground of mental pressure and nalgunda. Subsequently, disciplinary proceeding was initiated against the petitioner. He attempted suicide because he was under a spell of depression. No, Milord, then, during disciplinary proceeding against the petitioner, more or less similarity of the facts, the petitioner is examined by the doctor, Superintendent Institute of Mental Health, Hyderabad. He opined that the petitioner is fit to join the duty. He may be given duties not involving the use of or coming in contact with firearms. The doctor issued fitness certificate in favor of the petitioner. He was admitted in the hospital on 2/9/2000 and discharged on 15/9/2000. Similar to me, Milord, and during the said period, petitioner was treated for depression. Disciplinary proceeding was closed, punishment was awarded, removal from service. It is pertinent to mention that the medical report and fitness certificate were given a go by. My medical report is given a go by just in my case. Lordship is looking at, Milord, the court's reasoning analysis, Milord, paragraph 5, almost the last pages, last 2 pages. Oh. 1990.
Yes.
Milord, I will place, Milord, having Lordship liberty to place, Milord, last paragraph 13, 1-3. This has got some bearing on the present case. Members of the armed forces, as Lordship got it. Members of the armed forces operate under
Here the petitioner was not suffering from mental issues.
Depression is a mental issue.
That is the observation of the court. He had certain splinters to have
That is a
been.
physical injury. But then, Milord, Lordship looks at this and the earlier portion, Milord. I'm sorry, Milord, I should have drawn you lots of that.
Yes, paragraph 13.
No, before that, Milord.
That is the observation of the court, sir.
No, Milord, may I start from the beginning, Milord? The petitioner is appointed as Constable, Bhubaneswar. When he is deputed at Calcutta, Assam, the petitioner attempted suicide on the ground of mental pressure and nalgunda. Disciplinary proceedings was initiated. Then, Milord, next paragraph, the doctor issued fitness certificate in favor of the petitioner. He was admitted in the hospital on 2/9/2000 and discharged in 15/9/2000. And during the said period, petitioner was treated for depression. There is the court's finding. Petitioner is treated for depression. Here is the court is recording the facts. The splinter issue is, Milord, what happened, Milord, that is the physical injury. What happened, Milord, the Lordship goes to the facts of this case. I think a blast took place. A blast took in a state of depression, Milord. Milord, this Lordship knows, Milord, this paramilitary personnel have to work under great, Milord, mental stress all the time. So he was discharging his duty at a remote outpost. There a blast took place. He suffered splinter, physical injury. And then, my lord, coupled with that, he was also suffering from depression. So all these factors led him to this, into the suicidal thought in his mind. The main question is, my lord, he was suffering from depression. Then paragraph 13, my lord, the Miller finding of the court, members of armed forces operate under immense mental stress and strain due to the demanding nature of the duties, which often involve life-threatening situations, long periods away from family, and the responsibility of national security. The high-stakes environment requires constant vigilance, quick decision-making, and resilience, all of which contribute to significant psychological pressure. This is the judicial finding. When these already substantial stresses are compounded by additional external factors from the home front, such as military, etc., financial problems, family crisis, the burden can become overbearing. The compounded stress can erode coping mechanisms, and diminish the support structures that are crucial for mental well-being. Consequently, without adequate mental health support and intervention, members of the force may resort to extreme measures as a way to escape the relentless pressures. But otherwise, in other words, the court is speaking of the extremely sensitive nature of handling of this paramilitary personnel by the authorities. Very often, we read in the newspapers also, the trend is still continuing. From time to time, we find the members suffering from depression, resorting to various actions. It is imperative to acknowledge and address the dual sources of stress faced by the individuals to prevent such tragic outcomes and ensure their overall well-being rather than punishing them like removal from job. The court is holding that punishment is not the way to treat with these patients, Milord. The members of the force, they require, Milord, a sensitive hand. Anyway, Milord, at the end, Lordship was saying, Milord, with respect to the aforesaid discussion and the cases cited here and above, this court is inclined to quash the order of dismissal from service. My main purpose of showing this case before Lordship is that under similar circumstances, Milord, quashing of the dismissal order has also, Milord, made judicial sanction. And in recent time, Milord, from a court, Milord, the judgment has some persuasive value. Here, of course, before your Lordship, whatever persuasive value it is got, Milord, is single main judgment, but more or less, Milord, the circumstances, Milord. But all these things, questions will come after your Lordship will satisfied, Milord, about the decision-making process. I am emphasizing once more, and full compliance with the section and the rules. Then, Milord, Lordship says, Milord, the other points involved in this case will necessarily take us to the question of, Milord, punishment. What punishment? Assuming, Milord, assuming, Milord, I was held guilty, and, Milord, the General Security Force Court imposed the punishment upon me, then what is the remedy open to me departmentally? And how the departmental authorities have dealt with, Milord, those departmental, I mean to say, procedure. Milord, this is also another aspect, vital aspect of the matter. Because the General Security Force Court, Milord, the sentence passed, it went to the higher authorities for confirmation. Oh, Milord, I omitted to show you, Lordship, Milord, the section which speaks of confirmation of punishment.
Shantanu. চল বা ওদেরকে ওকে ডেকে দিই। আর এই কোথায় গেছে আদিত্য? Yes, sir.
My lord, section 107, confirmation. The punishment does not become at once effective. It requires to be confirmed by the higher authority. So the General Security Force Court's order required a confirmation by the higher authority. Section 107, finding and sentence not valid until confirmed. No finding or sentence of a General Security Force Court or Petty Security Force Court shall be valid except so far as it may be confirmed as provided by this Act. So it has got to be confirmed. And the punishment itself said that subject to confirmation. Well, I think I need hardly draw your lordship's attention. It's a matter of record. Now, after the punishment is imposed, lordship knows, not once from recounting the facts. It went before the higher authority for confirmation. At that stage, my lord, I made a representation before the authorities for, my lord, consideration, a representation against the order of punishment at the initial stage. Under section 117, it speaks of remedy against the order and finding. Well, briefly speaking, my lord, lordship need to go into the section, my lord. I can tell you, lordship, my lord, section 117 has got two subsections, 1 and 2. Section 1 speaks of representation, gives an employee a right to make a representation before confirmation. And subsection 2 gives an employee right to make a representation after confirmation. I availed of both these remedies. Now, what happened before confirmation? Now, when the first initial sentence, my lord, which later on remained the same, that on one charge acquittal, on another charge punishment, it went for confirmation. I made a representation. That representation was turned down. It's a matter of record, saying that the authorities are considering to send this matter back to the General Security Force Court for revision of the sentence. They have got a power to send it, remand it. So therefore, my pre-confirmation representation is turned down. Very well. I waited for the revision. The revision was held, my lord. Then after revision, my lord, the General Security Force Court, my lord, returned the verdict, the earlier verdict. So they said, no, we are not revising. We, my lord, reiterate the earlier finding of acquittal and punishment. In one charge acquittal and one. It went back before the authorities once more for confirmation. At that stage, my lord, I made this section 117(2) representation post. My lord, they went back, my lord. The authorities, my lord, what happened? This time, my lord, they confirmed. How did they confirm, my lord? They confirmed the sentence of punishment, but they did not confirm the sentence of acquittal. Lordship looks at this order of the confirming authority. Yeah? 204. 204. 204. Yes. 203, it starts the finding. It was first placed before the Inspector General. The handwritten note. I withhold confirmation and transmit the proceedings to the DG BSF. Well, he withheld confirmation as a whole, Inspector General. He was the immediate higher authority. Then it went before the highest authority in the BSF, the Director General. 204, next page, my lord. I do not confirm finding of the court on the first charge. I confirm finding on the second charge and sentence of the court. I do not confirm finding of the court on the first charge. What is the first charge, my lord? Under section 307, attempt at murder. There I was acquitted. The Director General is saying, I do not confirm the finding on the first charge. So your acquittal, I do not confirm. He is not confirming. I confirm finding on the second charge sent. So I confirm finding on second charge.
So according to you, it was without reasons?
Exactly.
It was arbitrary?
Totally without reasons. Because as far as this, my lord, judgment of affirmation, my lordship knows, my lord, judgment of affirmation does not record elaborate reasons. I affirm the lower court's finding, may not, my lord. Higher authority will not adopt this finding. But if there is a judgment of, what to say, my lord, difference, my lord, if the higher authority wants to defer the judgment of the lower authority, then, my lord, different reasons must be given. There is a universal rule everywhere. But here, my lord, no reasons are given.
Conclude here for the day, and
Next day, my lord, as your lordship please.
because there are other matters also. So how long will you take, sir, on the next date, wherein rules mainly you have placed?
I've got only, my lord, 4 case laws to place.
4?
4 or 5 case laws, as long as it takes. It will not take much time. I'll only, my lord, place the, my lord, the marked portion of the case laws.
Anyway. For the submission of learned advocate representing the learned advocate representing the Respondent Union of India is present. Next date we fixed on 16th of September.
16th of September. Lordship will give me. Huh? And at 2 p.m.
Yes,
At,
sir.
at 2 p.m.
After recess.
Recess. After recess. 16th.
Later will be court receptive.
Number 130.
I'm for the respondent, my lord. Permit me. I call my senior.
This is my appeal, Your Lordship. The application was dismissed. The application filed by the
Respondent insurance company.
filed by the claimant that was dismissed. Now the claimant was a police constable. Claimant was a police constable. So he suffered an injury, motor vehicle injury. Due to that injury, Your Lordship, the spleen was ruptured and removed. Twice it was operated. So after that, Your Lordship filed a claim application. The learned tribunal was of the opinion that since he hadn't lost any monetary benefit and still he is in the service, the application is dismissed. Now, my points are, Your Lordship, that the first, Your Lordship, the pain and suffering. He was badly injured. He was hospitalized twice. His spleen was ruptured. Your Lordship, spleen is the vital part. And that was removed, Your Lordship. So, Your Lordship, some pain and suffering ought to have been avoided. This is my first point. My My
Yes.
second point, Your Lordship, that the medical expenditure and the future medical expenditure. Now, the future, since he was injured, Your Lordship, and the further medical uh, treatment was going on, Your Lordship, even after the accident, so that some amount ought to have been awarded for future medical expenses. And Your Lordship, the third point, Your Lordship, the medical expenditure. Now, according to learned judge, the medical expenditure that was given by the medical insurance. But Your Lordship, my point is, Your Lordship, the medical insurance, that was a contract between the appellant and the medical insurance provider. There is a separate contract. So you see, even there is a judgment, division and judgment of the Honorable Court that even that was paid by the insurance company, that could be reimbursed by the insurance company. These are my 3 points, Your Lordship.
My lord, no loss as the claimant continuing his
Just,
service, my lord,
may
after
submit
this,
give the judgment
and getting salary also. And no whisper about receiving of medical facilities from government. My lord, he is a government employee. And my lord, I'm highlighting in the paper book the observation of the learned tribunal, page 25 of the paper book. From 25 onwards, this, my lord, in the second, Roman second, it has been observed neither his posting, page 25 of the paper book, my lord. This is figure 2, neither his posting nor seniority nor salary was affected by any manner even after accident. It is the observation, my lord. Then, my lord, PWD in the bottom, PWD 3. In the 4th line, his examination, he identified some documents which are marked as Exhibit 9 to 12, but he admitted in his cross-examination that after operation, the patient became fully cured. My lord, in the bottom. Then, my lord, in the page 26, paragraph 3, in the bottom, alleged accident was happened at 12:15 p.m. while PW1, PW2, Exhibit 4 shows that it was happened at 12:15 a.m.
I will place
both are not only contradictory in nature, but also touches the root of the merit of this case and shakes the credibility of the claim. It seems more serious as because the claimant did not opt to give any explanation even after opportunity was given to him by this court, wide order, number so-and-so, dated so-and-so. So it cast cloud of doubts in happening of the incident and involvement of offending vehicle in accident. Then, my lord, page 27, 3rd paragraph, in the bottom, except multiple severe injuries, he was not suffered from any other complications. That injuries were also cured by treatment. Then, my lord, petitioner, the bottom, before, petitioner did not prove the nature and extent of the injuries and expenses allegedly borne by the petitioner accrued in his treatment seems excessive and imaginary. Then, my lord, in the 4th column, whether the claimant reimbursed the said amount from government or not. Then, my lord, page 28, 3rd paragraph. Claimant neither made any specific statement nor submitted any document like disability certificate in support of his claim. So I do not find any substance in his claim of compensation for his disability caused to him after accident and unable to perform his duty. Then, my lord, these are all paragraphs where this has been mentioned. Then, my lord, page 29 and the half, he is getting his full salary without any deduction. Then, my lord, in this 3rd paragraph, he further claimed compensation for loss of his monthly earnings of rupees 4,000. As he stated in his examination in chief on affidavit that he lost earning of 4,000 per month and he used to earn by private tuition and running nursery, but now he fails to earn the same after accident. So he claimed the same in compensation in the head of loss of his earning capacity due to accident. Then, my lord, page 30. In the second paragraph, it also appears that both vehicles were in motion and coming from opposite side, and they collided head on, but owner and insurer of other vehicle were not impleaded, and OP contested this claim on this ground. Then, my lord, in the bottom side, there is one claimant failed to prove time and manner of occurrence. The tribunal also concludes that claimant is neither suffered from any sorts of disability, nor from deduction in salary, nor from posting. These are the observations of the learned tribunal. My humble submission to your lordship, let the tribunal's observation may be upheld. This is my respectful submission to your lordship.
Lordship, kindly come
Where
to
is
the
the charge
FIR.
sheet?
Charge sheet of the
Yes, charge sheet.
Charge sheet the page.
Where is the charge sheet?
Lordship, the page 44.
Any injury report is there?
Any injury report?
Injury doctor was examined, your lordship. Injury report is there. Doctor was examined.
Where is the report?
I'm asking you whether there is any injury report. Doctor had conducted the operation.
Your lordship, the discharge certificate page,
Discharge certificate was for the removal of the spleen. I'm asking you if there was an accident, there must have been certain external injuries.
It was taken to nursing home, and those were mentioned in the discharge report, your lordship. The injuries were mentioned.
Where is it?
Page 56, your lordship.
This doctor was examined.
Your lordship. Page 16, your lordship. PW3. PW3, your lordship.
W2. Oh.
Page 15, your lordship. Kindly come to page 15. Dr. Manav Straman.
How was the medical expenses disbursed?
Lordship. 1,06,000, Your Lordship, that bill was given. That was exhibited, Your Lordship.
Who paid for the bill?
Your Lordship, my instructions, it was paid by the insurance company.
Which insurance company?
Your Lordship, there was an agreement with the government with the insurance company to pay that, Your Lordship.
Agreement with the government to ask the insurance company to pay. What kind of an agreement is it?
Your Lordship, I find, Your Lordship, the insurance company's bill is the insurance company, but it was in the bill, it is paid by the insurance company.
When was this matter fixed for orders, sir?
Your Lordship fixed for
5th May
So you did not have you did not get the time to at least flag the pages.
Your Lordship, Your Lordship, it was paid by the insurance company. Your Lordship can come to page 60.
60.
Lordship, patient details, thereafter company, National Insurance Company Limited.
Which page?
Page 60. And party paid cash in the bottom, party paid cash 8,217 and other services.
National Insurance Company Limited.
Your Lordship. That was Mediclaim benefit, Your Lordship.
Now the where was he posted?
Raiganj, Your Lordship, as constable. Uttar Dinajpur, Raiganj, Your Lordship, as constable. West Bengal Police. No promotion, Your Lordship.
Where is his evidence?
Your Lordship.
Which page? The victim's evidence?
Page 15, Your Lordship. PW3.
Page 15 is the evidence of the doctor.
Doctor.
So I'm asking, where is the evidence of the victim?
You have to kindly come to page 9, Your Lordship. In the FIR, it is mentioned, Your Lordship, in the night accident was caused at about 15 minutes.
So in page 11, sir, you also no salary or benefit was deducted during the period in which I was under medical treatment. I have not filed any document of permanent disablement. আসুন।
This copy also.
দিয়ে দাও, কপি আছে।
You can come to page 115, paragraph 26 onwards. Page 115.
আচ্ছা, কপি আছে।
Paragraph 26 onwards. Your Lordship. অ্যাক্সিডেন্ট ওখানে আমি অনুমান রাত্রি 12:15 নাগাদ বাড়ি থেকে বেরোই। অ্যাক্সিডেন্ট ওকার at night 12:15. The recording officer of the police station, he referred 12:15 hours instead of 00:15. That is at page the formal FIR page 38. Lordship, column number 3. Lordship, the incident occurred at night. The learned tribunal says it is in the afternoon. That's why. AM at night, Your Lordship, 00:15. Lordship, in the written complaint, রাত্রি 12:15। The recording police officer made the mistake. Even PW says Rakti
My lord, I am for the respondent.
I'm appearing on behalf of the appellant, my lord. I've preferred this appeal.
Now you tell me all the exhibits and everything properly.
I've preferred.
Have you failed?
I-
Have you failed?
I've preferred this appeal on the point
I
of.
really didn't understand whose matter it was.
He's lucky. On the point of income, accident of 2012, there was no the income was not proved in accordance with law.
What was the salary? What was the income taken by the tribunal?
Victim, the claimant stated that the victim was an auto driver. Tribunal, and he was earning 6,000 per month. Tribunal took 6,000 per month. 2012 accident, 4th October 2012. That is one ground. And the other ground is, my lord, interest. 7.5% has been granted. I pray for 6%. And the third being driving license, my lord. I had taken one ground that there is a mismatch between the Form 54 and the DL extract. But I must be candid that no evidence is there. Another thing, my lord, three vehicles were involved in the accident. Charge sheet was filed against the drivers of 2 vehicles. The charge sheet has not been exhibited. On the last occasion, my lord had directed me to produce the typed copy. I have the copy of the charge sheet. This is the typed copy. From this, my lord will find. So I pray for that order of recovery as per Kenei from the other vehicle. These are my 4 grounds.
No, where is the
my lord?
Where is the conclusive part?
Conclusive part, my lord will kindly see during investigation. Before that, my lord will kindly see the first page, 10A. Number of accused persons charge sheeted 2 in the middle portion. 2.
Eyewitness, which page?
1 second, my lord. Eyewitness is at page 11. Page, it's between page 12 to 13. PW3. But it's the case of the claimants also, that there were 3 vehicles involved. My lord will kindly come to page 3 once, their claim application. My lord.
But the eyewitness says 2 vehicles.
My lord. So that's what I pray, my lord. The right to recover from the
collide with the vehicle. Now, this has not been mentioned in the charge sheet.
No, the charge sheet, there were 2 accused persons. Eyewitness says that
Charge sheet is at?
Charge sheet, it has not been exhibited, my lord. I have produced the typed copy as well as the original is with me. It has not been exhibited.
Did you take this plea before the tribunal? No.
No, yes, it has been taken. My lord will kindly come to page 23. PW2 is 3 is the eyewitness.
PW3?
My lord.
PW3 is the eyewitness.
Eyewitness, my lord. Page 12 to between page 12 to 14. Is the though he stated in his examination in chief,
the 2 vehicles
my
were
lord
involved in the said accident.
But the third vehicle, it was since it was unknown, it was not.
So you have only this statement.
I have this statement.
Now, that has come up in the cross-examination. How did the tribunal deal with it?
This page 23, it was not dealt with properly.
No, this page 14.
It was not dealt with. Only this page 23. That's it.
Where is page 20? What
Page
has been
of the,
there in?
just
there in
what
page
the eyewitness, page 23, what the eyewitness stated. And furthermore, the claimant applicant did not produce the charge sheet in connection with Hastings PS case number such and such. And as such, the tribunal is in dark as regards the liability of the vehicles involved in the accident. But the charge sheet, the copy, my lord, it's there before my lord.
No, in the you made the other insurance
No,
company a party.
they did not make it. It's their case before the tribunal.
Did the other insurance company appear before the tribunal?
My lord, we did not make the party other insurance companies, my lord. As we, my lord, we follow the judgment of the Honorable Apex Court Khenei. So, my lord, we only party the vehicle number CJ05B6453. Only lorry.
So the tribunal had taken the notional income.
Yes, my lord.
Notional 6,000 2012 without any evidence.
You have got the copy of the Khenai's judgment.
Yes, my lord. My lord, paragraph number 22.3. Page number 286. Three. Page number 286. In case all the joint features have been implemented and evidence is sufficient, it is open to court tribunal to determine the extent of composite negligence.
You give me that extent where that percentage is to be determined.
My lord, that paragraph. My lord. Supreme Court cases?
Supreme Court cases.
My next ground, the next matter, yes, it's mine. My lord, my lord. I'll take help of Mr. Singh. Subhashish education. পারবে তো ওই জাজমেন্টটা দাও তুমি বার করো পার্সেন্টেজটা কোথায়
কাটাকুটি কম to the extent.
I'm afraid
My lord, I am appealing for the respondent claimants number 126, my lord.
Make it as simple as possible.
One ground is my lord income. Accident of 2019. Claimants prayed for income of 8,500 per month. Tribunal accepted. Tribunal gave 8,500 per month, and that's why I preferred the appeal. Number one is income. Number two is my lord interest, 10%. Tribunal directed that insurance company should pay within 60 days along with specified interest. In default, 10% interest.
8,500 for what?
He was alleged to be a supervisor under a government contractor. And PW3 is the, my lord, the alleged proprietor of that government.
Page.
My lord.
Page 1.
Page 13. He produced three payment vouchers, my lord. Those are exhibit 12 series.
Who is this person?
This person is, he says that he is the government contractor under whom the victim was working. But the difficulty, my lord, the contradiction, this is an accident.
Exhibit 12 series, which page?
It starts at page, my lord, 46. 40, my lord, I'm sorry, page 34. Page 34 onwards. Wages certificate.
Date. Any register?
Nothing. And the trade license that he produced, that was
Yes, what you have to say?
the trade license, my lord, also that he produced, that was from that was valid from 2022 till 2025. That's in his cross examination. And the accident is of 2019.
No, trade registration date is there. 12th of November 2018.
Yes, it is.
Registration number is there. Don't try to be.
No, I did not see that. I did not see that. And my last round is the driving license. It was neither seized nor produced. So I pray for that.
Yes.
Yes, per month income was 8,500, my lord, and number of dependency of the victim, my lord, 6, my lord. So, my lord, 8,500 very eligible, my lord. No, my lord.
My lord, yes, just send me the paragraphs. এটা কত নম্বর ছিল?
My lord, page number 283, paragraph 15, subpara 7.
No, no. ওই ইয়েটা জাজমেন্টটা
Judgment. আমি তো কি আশ্চর্য আমি তো
I have seen this. I did not ask you to find out this.
The percentage,
That proportion
that
part.
proportion has to be decided by the tribunal in a separate proceeding. My lord, we can see that paragraph 20.
But then there is a particular judgment.
Then may I come back to that? Only this matter may I come?
My lord, page number 286 is specifically written in the
Particular judgment.
I'll come back, my lord, this matter.
There
My
is
lord,
a particular judgment.
On that proportion.
Yes, the rules have been set.
Is that judgment? Really?
My lord, the apportionment may kindly be 50-50. 50-50.
That is at page
That is my lord, page number 283. Paragraph number 15, subpara 7, my lord. 7, therefore, when from the bottom, G, 50-50.
Is this what my lord is referring? Kenny is the judgment.
No, proportion specific 9 because of.
No, not this one.
But your lordship is referring to a particular proportion, my lord, to be distributed among the tort pieces.
I saw one judgment.
If your lordship
I
can.
have a copy. You come back tomorrow.
If lordship just indicates the principle, my lord, on what it was.
On the distribution, where this court has, this issue was not decided and thereafter it was decided at a later stage. Where's Mr. Mondal? I think in one of his
tort fees is there, proportion টা ট্রায়াল কোর্ট ডিসাইড করেনি আর সুপ্রিম কোর্ট ওটা বলেছে এটা এই পার্সেন্টেজ এটা এই পার্সেন্টেজ এটা এই পার্সেন্ট বাট মিলট ইন ভেরি মেন
Q Anthony. Well, that has been deferred here. That has been deferred, my lord.
I'll get this as well. We have found it.
149.
This is my appeal. I got the respondent claim. I will assist your lordship. I will assist. I am. Your lordship, my appeal, there's a court also. I'm starting with my appeal. My appeal is for twofold. I have submissions of twofold. The appeal has been filed. Firstly, on the ground that the income we have disputed, wherein the notional income has been given to them as 6,000 for Mashon. The date of the date of accident is 4/6/23. There's no evidence.
Where is he?
That is first point. And the second point is, your lordship, on the other heads, it has been given much more. Kindly come to page 20 first of the paper book, your lordship. 20, running page 20. Your lordship will. Yes, your lordship. Your lordship, on column 10, loss of filial consortium, rupees 80,000. No, 70 should be 77, but they have 80,000 filial consortium should go, spousal consortium, and this loss of estate, funeral expenses is okay, Your Lordship. it should be 77.
Calculate.
কত হচ্ছে 80 হচ্ছে হ্যাঁ it is 80, Your Lordship.
And future prospect and okay.
Everything is fine, Your Lordship. That is
Can
the
you
2
do the
points.
calculation? What about
My case, Your Lordship, that the accident occurred in 2023. Now, the deceased used to earn rupees 10,000 per month as mason. The London Tribunal assessed 6,000. But, Your Lordship, according to Labor Department circular, Your Lordship, it is per day 368 in the 2023, Your Lordship. And even in Lordship, Supreme Court in the recent judgment says that in 2016 case they allowed 10,000 on the basis of the evidence given by the wife. I've cited that judgment, Your Lordship.
That to presenting the appellant. Mr. Singh, 151.
But I was wondering whether my lord's officers would be.
No, yesterday, their hands started to pain. Both of them were crying.
Today it will come out, my lord.
No. Today I had been more. Yesterday, both of them took.
Case, my lord.
They're cursing inside.
Look, because tomorrow again, your lordship had asked me all the officers to come up with your lordship after 4:30.
So that's why I need to finish this off.
Lordship. My lord, it's
So then tomorrow. Yes, sir.
my lord, this death case, an award of the principal sum of rupees more than 72 lakhs has been passed. The victim, the 42-year-old man, he had a jewelry.
2 lakhs, that means income must be secured.
Yes, my lord. Income was on the basis of income tax return, my lord. The award has been assessed.
Yes.
My lord, I have deposited more than 90 lakhs before my last court, my lord.
So income is not disputed.
My lord, income is not disputed. My lord, I was on the point of this managerial loss.
Similar
victim,
to that one.
my lord, similar to that one, my lord. In this case, my lord,
There was one. The factory run by that lady.
Lady.
No, that travel business.
Travel business, my lord. My lord, in this case, I am a little on the weaker foot, my lord, because the victim, my lord, was running a jewelry imitation shop. My lord, he died. My lord, the only sentence what I am, my lord, harping on, my lord, as I'll indicate to your lordship, my lord, it was by the widow. If my lord kindly comes to page number, my lord, 19 of this paper book. My lord, the evidence of widow, the PW1 starts at 15. I was inviting your lordship, my lord, to page number 19. Because, my lord, managerial loss, my lord, the principle is if the business is continuing or running, my lord, only, my lord, the amount which is spent on the manager to run the shop is to be, my lord, considered to be the loss of business or the loss of dependency. My lord, the last fourth line of this cross-examination, page 19. Obliged to your lordship. Obliged to your lordship. My lord, this is the main crux, my lord, on which I was harping upon. Because, my lord, prior to the death, my lord, the victim's income tax return was lordship. Lordship, my lord, I was saying I am a little on the weaker foot, my lord, on this case. My lord, the pay and recovery right has already been granted in this case. So your lordship will kindly not interfere with that. Your lordship will kindly record that. On the point of, my lord, this is at page number 35 and 36. My lord, the award passed by the learned tribunal starts at page 26. I was inviting my lord to page 35. My lord, this is the observation, my lord. And my lord, the last part of page 35, the OP insurance company, my lord, last fifth line. The OP insurance company is not obliged to pay the compensation as paid for. Accordingly, the owner of the offending vehicle, my lord, this is it. And my lord, page 36, if my lord kindly comes to the finding, my lord, this, my lord, on the ground of, my lord, no route permit. My lord, the finding, my lord, is at page 36, the finding of the learned tribunal, my lord, if my lord kindly comes to the next page, third line. To render substantial justice, the OP insurance company will disburse the company's lordship. My lord, I was saying, my lord, the lordship will kindly not interfere with it. My lord, my lord, when it is, my lord, specifically, my lord, learned tribunal. Lordship. No, your lordship. Lordship.
That's it.
Of managerial loss, I would be able to get some more documents, Millard, because
No,
nothing.
Sir, it is by mistake.
No.
By I
No.
accrued interest. No one asks for this line to. You know how many কটা হলো আজ? 10টা হয়েছে? হয়েছে 10টা? হয়েছে? ও 12টা হয়েছে? Okay, then let us give them some. Yes.
But kindly, my lord, allow me, my lord, to trouble your lordship at this late hours. My lord, three, my lord, brothers and sisters of our fraternity are in trouble. My lord, I tell your lordship, my lord, and can you, my lord, have a look at this order? My lord, kindly do not take me amiss. My lord, there is a direction, my lord, for upon the bank to file a report. My lord, a learned, my lord, junior member, my lord, of the bar, my lord, who coincidentally happens to be my sister-in-law also personally.
I don't know.
My lord, she was present. My lord, that's why, my lord, I can.
Brother-in-law,
My lord, that's why, my lord, I have the personal knowledge.
when the,
My lord, she was present, but my lord, she could not speak it out.
listen,
She could not
Delhi
speak it out.
pass these orders because
It possesses faith and trust on us.
Kindly.
My lord,
no, sir, every day.
but